In a very peculiar situation, I mentioned this matter. This is the contempt application. It has been affirmed when the commissioner has signed, but the filing section is not accepting this on the ground that in the body of plan you have to take again the cost title of the writ petition, prayer of the writ petition. I have also quoted that, my lord. It is there, and it has been affirmed, my lord. But the filing section is not accepting. It is affirmed, signed by the commissioner. And the cost title, full cost title, prayer of the writ petition is at the first page, my lord. It is there. Full cost title of writ petition and the prayer of the writ petition.
Yes. Why is it not being accepted?
Well, if your lordship directs, the file will not accept.
Okay, leave to file for it.
Much obliged.
Yes.
Only motion without electricity. Only electricity application was made, local club disturbed. Accordingly, distribution company, my lord, has went under revoke section 3 of the Licensing Act. The magistrate has taken up the matter. Magistrate also, my lord, is of the view that since there is a dispute and it is an open land I purchased for purpose of cost.
In due course, Mr. Bhattacharya.
I have filed it for item 166 without electricity. I cannot stay there.
Upgrade it on Monday.
160.
Well, may I seek kind leave?
He's senior. Yes.
I have
Lord,
not
may I
seen.
briefly mention, Lord, for inclusion or motion in the list, Lord. Since it is a matter of 2022, that's why the matter is not having it.
No use of including the matter. Or anyway, hand over the slip. Yes.
My lord, the petitioner is an advocate of Bardhaman Court, my lord. He protested against some law clerks. They used to supply, my lord, BD Gaja to the remand accused, my lord. So,
BD is all right, but Ganja is too much.
yes, my lord. It is my allegation. My lord, I have made complaint to the district magistrate as well as.
What is the cause of action?
Yes, my lord. District magistrate, my lord, banned me totally from that to entering into the court.
Banned whom?
Me, being an advocate, my lord, the petitioner, not.
No, obviously. Yes. So what do you want now?
My lord, leave to my lord move because my matters are there.
Very well. Leave is granted. It will appear as another in top on Monday.
Well, I'm grateful.
Lordship, item number 194 of your lordship today's list. I want my lord to withdraw it because my lord.
To be mentioned on Monday. To be
Okay,
mentioned.
Grateful,
Monday.
grateful.
Give us slip.
Lick it.
Your Lordship,
Okay.
may I be permitted to mention this writ petition? I've already solved my other side. In this writ petition, I'm only praying for expeditious disposal of my section 14 application.
What is the item number?
Your Lordship, it's running in the monthly list as I shall mention the item number and hand
With
it
the
over.
item number, it will appear under the upgrade.
Lordship, may be permitted for upgradation of a matter, Lordship, is appearing 310, your Lordship. Lordship, the matter is dates back to 2022, your Lordship, for the appointment of a Muslim marriage registry, Lordship. Matter has not been heard, Lordship. Lordship, it has not been heard for even once, your Lordship.
No.
Lordship, the matter dates back to 2022.
No. Call on the list.
To mention item number 1.
This item number 1 is probably my matter, but the cost title erroneously, my lord.
It will appear properly on Monday.
Monday.
Top item number 2.
My lord, I am for the petitioner, my lord. I am for the state respondents. Before your lordship takes up matter, my lord, I am tendering unconditional apology due to my laches. My lord, your lordship's order dated 19th of October has been communicated to the chairperson of the CWC at a belated stage. So, my lord, the report on affidavit could not be affirmed, but otherwise, if your lordship kindly excuse, the report is ready as well as the affidavit in opposition and reply. So, your lordship can hear out the writ petition. I am not seeking adjournment.
What is the matter?
Matter is that the petitioners are the paternal aunt of a child who is now 13 years of age. He is living in a home, my lord. He has no father. His father expired. And he is living in a home with the help of the CWC only. He is living in the home of Ashirvad of Hope Foundation, my lord.
Right.
And from time to time, with the increase of the age of the child, my lord, they are changed from one home to another. My lord, now the petitioners, they are the paternal aunts and they had the visitation right. They used to visit the child occasionally. And it has been reported by the home authorities only that after the visitation of the aunts, the child had developed mentally, had some positive development.
Child is a he or a she?
He, my lord.
He has his biological parents are there also?
Mother is alive. Father expired, my lord.
So mother also goes to see him?
Yes, no, my lord. This is the main problem. Mother is very reluctant whenever she is called from the home.
What do you want? Do you want visitation, right?
My lord, only they used to visit regularly, even during the COVID period, since there was no physical connection could not be given. My lord, they had access over telephone. But after September 2021,
they were not even allowed to call the child over phone also. So I say,
Maternal aunts, paternal aunts.
yes, my lord.
Yes, what is your report?
My lord, one thing I want to draw your lordship's kind attention, my lord. The Hope has submitted a report on the last occasion, my lord.
Hope was
And
directed to file a report, probably.
the respondent number.
Yes, a copy of report was.
Yes, my lord. My lord, if your lordship kindly come to page number 5. Because there no pagination is made, my lord, point number 14, where a report has been sought for from the Child Welfare Committee, the present administrator only, my lord, the present chairperson. And from the change of administration, my lord, this thing has cropped up of the CWC.
Item 14, what are you trying?
My lord, in the from the report, my lord, page number 5, the relationship among the family members, my lord, with the child. My lord, if your lordship kindly see item 14, it is dealing with the child and relative, it is cordial. Mother and siblings,
Father and mother, not applicable, father died.
My lord. Mother and child, non-cordial. Kindly see point number 3.
Yes.
So only, why they are not allowing, I don't know.
My lord,
you are the state. You're for
yes, I'm for the state respondents.
CWC.
I'm not for the Hope Foundation. I'm for the respondent number 1 and 2.
Right.
My lord,
what is your stand in the matter?
Yes. Now, my lord, in this matter, affidavit has already been exchanged.
The Child
Apparently,
Welfare Committee is there.
yes, my lord, apparently there is no quarrel with the writ petitioner. Now, the stand taken by the CWC is very clear and specific. Now, my lord, kindly appreciate the interest of the child has to be given, my lord, utmost importance. Now, my lord, this is not a boarding school. My lord, somebody, my lord, will go to the boarding school and, my lord, meet over there, hand over some chocolates or something. This is not done. This is a home where most of the inmates are child in needs of care and protection. My lord, 3 kind of persons can be allowed. My lord, the biological parents are there. My lord, the present chairman of the CWC, even he has affirmed an affidavit, she has made an endeavor to impress upon the writ petitioner that you apply for foster care or a interested person, fit person in terms of the Juvenile Justice Act. They are inclined, they are not ready to take the responsibility of the child, and they are only interested regarding visitation. If they are interested about the child, of the well-being of the child,
interested to take foster care, but not to visit. Where is the bar?
Then, my lord, kindly sees the fit person. The definition of fit person, they can make an application.
They can, but they won't.
My lord, then lordship kindly sees
page. There is a bar in visiting.
My lord, 73. Openness and transparency, the West Bengal Juvenile Justice Rules 2017.
Is there any provision of bar?
No, my lord, these persons subject to correction, my lord, these persons can be allowed. What I am trying to impress upon your lordship, this is not the system of the homes that somebody, some maternal aunts or somebody can be allowed and come over there. My lord, it has an adverse effect to the other inmates subject to correction. Well, let them take the responsibility. They say that the child is safe in the custody of the CWC because of there are criminal antecedents of his father. But his father has expired on the 20th of July 2020.
No, the
And my lord,
other persons may be also permitted who are
my lord, kindly
as the
sees,
concerned department or directorate
yes,
or management committee.
So, my lord, only maternal aunts. Now, my lord, an interesting averment is
Paternal.
being made. Yes, paternal aunts. Now, my lord, interesting averment is made in the affidavit in reply, where say the petitioner number 2, she is living abroad presently. I don't understand, my lord. My lord, the Child Welfare Committee is very much willing to hand over the child.
As per this, even the biological parents are not permitted.
No, my lord, the biological parents are permitted when they are in the custody of the CWC with the permission of the CWC.
Rule 73 does not make any exception for biological parents also. It only says open to visitors with permission of the board of the committee or the person chair who may allow voluntary organizations, social workers, researchers, doctors, academicians, and such other persons.
So
there is no exception between aunt and biological parents also.
My lord, subject to
If the mother is permitted to.
so, my lord, subject to correction,
Yes.
mother, my lord, biological parents, my lord, there
So
is no
biological
no,
parent,
my
there
lord,
is no distinction. If you are relying on this, there is no distinction between biological parent and others.
no, my lord,
Even they cannot visit.
my lord, even subject to
That would be an
correction,
absurd
my
proposition.
lord, subject to correction, I am putting this question to myself that if the petitioners are interested regarding well-being of the child, what prevented them from making an
So, Basu,
formal
there are
application?
several reasons which may
So, my lord,
no, one person, you cannot blackmail them like this. That
No,
you
my lord.
have to take foster
My lord.
care if you want to visit. No.
my lord, there
definitely.
is no
Mr.
question
Basu,
of
let me
blackmail.
complete.
My lord.
Let me complete.
My lord.
There are several reasons for which people may not have the infrastructure to take foster care. They may not have that sufficient number of people in their home or sufficient means even. So they, for that reason, they can't visit even. How can this be a valid argument even?
No, my lord,
You have to take foster care to visit. Definitely not. If they are permitted to visit, if the mother is permitted, there is no exception for biological parents. If the biological parents were competent in the first place, Mr. Basu, they would not be in the home.
no, my lord, I
You
have
have to
made
keep that in your mind.
under subject to
Grateful to your
correction, my lord,
lordship.
I have made an endeavor to impress upon your lordship that this is the other childs are there.
So tell me the
My lord,
reason why the mother is being made an exception with, as per Rule 73. You cannot blow hot and cold in the same breath. Either you rely on Rule 73 or you don't. If you rely on Rule 73, it does not make any distinction between biological parents and other relatives.
my lord, this
So
is
if that be so,
this
why
is
are
the-
you allowing the mother but not them? I
my
mean,
lord,
give me one reason.
my lord, this is the affidavit, so I cannot, my lord,
Show me the affidavit.
make, my lord,
Non-affidavit.
yes, my lord, the affidavit is there and Rule 73 is quoted, so I cannot take any stand contrary to
So
that.
this is not an affidavit. You said
No, this is on affidavit
you said
regarding.
it was not affirmed.
Yes, this is
No, my lord,
affirmed.
the
My
report
lord, the
is not
affidavit.
affirmed. Which
No,
your lordship-
report is not affirmed, but the affidavit in opposition and reply to
Acha.
this writ petition is already, my lord, there.
So report, you file the report. The report says the same thing.
My lord, no, the report says, no, your lordship's specific query was how frequently the mother visited the child. My lord, this is the report.
Give a copy to her also, Ms.
My
Basu.
lord.
Thank you.
The report ends with, for any further clarification, feel free to contact. Report being filed.
I am tendering apology. This is my fault because only yesterday it is handed over because of
Very careful on this.
my lord, because of my belated communication.
This is not done. A report definitely cannot say that for any further clarification. This is not
No,
a
my lord,
communication.
probably no, my lord.
Not
This
even
is
a communication. This is a report filed by court's direction.
no, my lord.
Dare she?
No, my lord. Kindly, my lord. She has handed over this report on an understanding that I'll be making submissions on that basis. My lord, there is a direction upon the my lord, the respondent to file report on affidavit. So I have already communicated. That is my latches. I have communicated this on a belated stage.
I'll pass an direction directing you to give them visitation.
Grateful to your lordship.
Yes.
Your lordship directed me to
But
add
my lord-
the mother as a party. I have already added her and communicated, but I am filing the affidavit.
Now, my
of
lord,
service.
this paternal aunt, one of the paternal aunts, what I understand, my lord, there is an averment in the affidavit in reply that she is staying outside the country. My lord, how this
Maybe,
petition,
my
my
lord, why one stays outside the country.
The
one is-
petitioners are the paternal aunts of a minor child who is about 13 years of age. Whose of the child has been placed in a home that is Despora number 3, the Hope Kolkata Foundation. So what was the reason for placing the child in the home in the first place, Mr.
My
Vasu?
lord, there was a complaint that this child was not looked after by the parents. Father has criminal antecedents.
Yes,
My
sir.
lord, mother was found begging in front of a mosque with the child. My lord, these are the
Transpires that the reason for placement of the child in the said home under the Juvenile Justice Act was that he was not being looked after properly by his biological parents. The father of the petitioner had criminal antecedents, although he has expired in the meantime. Next para, even the mother of the child, it was alleged, was found begging in front of a mosque with the child, which was not found to be congenial for the upbringing of the child. Under such circumstances, the child has been placed in the home. Next para, it is contended by learned counsel for the CWC that the CWC may make exceptions for biological parents of a child who is placed in a home, but the petitioners do not have any right as such, in the capacity of paternal aunts, to visit the child as and when they please. First up, it is submitted that such visits would not be congenial to the atmosphere of the home, since the other children who are also primarily children in need of care, may feel embarrassed or discriminated if the particular child is met with by relatives. Push up next para, it is submitted that in the event the petitioners are so interested to visit the child, they are at liberty to apply under the appropriate provisions of law for taking foster care of the child, to which the CWC has no qualms. Push up next para. uh, Learned counsel for the CWC submits that due to some unforeseen circumstances, the report as directed by the court could not be affirmed. However, a written instruction in the form of a report is handed over in court today. Next para, it transpires from the said report that the mother of the biological mother of the child visited the child on 4 dates in total. The first such visit was in the Ashirvad Home for Boys on August 31, 2019. The second visit was in the same home on February 22, 2020. The third and fourth such visits were at the Crisis Intervention Center for Male on December 28, 2022 and October 14, 2023. Next para, thus, it is seen that over a period of about 4 years, the mother has only visited the child on 4 occasions, making the visit a mere annual affair. Next para, thus, it does not strike the confidence of the court that the mother is too keen to visit the child. Next para, hence, the discrimination sought to be made by the CWC between the biological parents, within bracket, only mothers since the father has since died, bracket close, and the paternal aunts of the child is based on a flimsy pretext. Next para, the CWC seeks to place reliance on Rule 73 of the West Bengal Juvenile Justice, within bracket, Care and Protection of Children, bracket close, rules, 2017, which, however, does not make any distinction between biological parents and other relatives. Subsection Subrule 1 of the said rule provides that all child care institutions, CCI capital, shall be open to visitors with the permission of the board or the committee, BSC capital, or the person in charge, who may allow voluntary organizations, social workers, researchers, doctors, academicians, and such other persons as the concerned department / directorate / the management committee may permit or consider appropriate, keeping in view the security, welfare, and the interest of the children. Next para, thus, the discrimination meted out between the biological mother of the child, who was found to be unfit to retain the child in the first place, which necessitated placement of the child in a home, and the paternal aunts / petitioners of the child, who are also keen to visit the child, is baseless, unreasonable, and arbitrary. Next para, since the mother is being permitted to visit the child, there is no plausible reason for refusing the petitioners similar right to visit the child. Next para, of course, such right of visitation cannot be unfettered and would be under the aegis of the concerned home. Next para, at the time of such visits, comma, the petitioners shall not, comma, if not so permitted by the management of the home, comma, hand over any gift to the child, comma, if in the perception of the home authorities, it transpires that such gift would create an inferiority complex or otherwise affect the other children at the home. Full stop. Next para. In view of the above observations, comma, WPA 28562 of 2022 is disposed of by directing the respondents to permit the petitioners to visit the child once in 3 months on a date fixed by prior appointment. Full stop. Such date shall be fixed according to the convenience of the petitioners and the home. Full stop. The petitioners shall, comma, in advance, comma, communicate in writing to the concerned home before such visitation to fix the time and the date and time of such visitation. Full stop. Next para. It is made clear that nothing in this order shall confer any special right or equity in favor of the petitioners vis-a-vis the custody of the child or the foster care of the child. No address to cost or the settlement.
Grateful to your lordship.
একটা লাইন অ্যাড করে দিও, the report filed today be kept, the written instructions filed today be kept on.
Grateful to your lordship.
Item 3.
I am for the petition, lordship.
I appear
On the last occasion, lordship was pleased to direct the CSC authority to make an inspection and to submit.
There was a
report.
direction to file a report of subsequent in respect of an inspection. And
What
if
was
an-
the occasion of the writ petition?
Lordship, petitioner complied with all the formalities for getting the new service connection, including payment of the service charges, but due to the objection of the private respondents, the CSC authority could not give such connection.
No, today I am in difficulty. We have inspected. We have also found out a separate route, my lord. We are ready and willing to provide the service. But my lord, the report is not ready.
Why not? I'll impose cost on the CSC.
My lord,
No.
my lord,
Direction was given
my lord,
long
I am,
back.
yes, my lord, but
19th of October. Today we are in on 1st of December.
my lord, I appreciate, my
No, I'll
lord.
impose
My lord,
cost on your.
if my lord may kindly take it up on Monday, my
No,
lord.
why? Why should it remain be left till Monday? No.
My lord, we are ready and willing, my lord. There is an alternative route also we have found out. But only
They have to be given a copy. Why weren't
But-
ready for so long?
my
The
lord,
direction was given on 19th of
I
October.
will take it up at 2 today.
Yes. Learned counts when the matter is called on. আচ্ছা ঠিক আছে, এটা কোনো record দেওয়ার দরকার? 2 p.m.
I'm
Come back at
Lordship.
please give a copy to both of them.
My lord,
Lordship.
Please don't escape from bar station room number 13 so that they cannot give the report. Take the report.
Item 4.
Item
What is
4,
that?
my lord. I'm for the petitioner, my lord.
Lordship, I beg to appear on behalf of the respondent number 1 and 2.
File the affidavit of service, my lord. But I have served the bank. I have served the state authorities also. I've made a speed attempt.
Bank is the main respondent.
My lord.
You are appearing for the
I'm
bank. Let us hear you. Yes. What is the matter?
My lord, the matter is, I'm an absolute owner of a premises 26D in Amastro. Now, my lord, bank has granted loan to the borrower, who is not me. I have not taken the loan. Bank has granted loan to the borrower against properties 26E and 26D. Now, my lord, 26D was a property gifted to me by owner of 26E.
They have taken out a surface proceeding.
Yes, my lord. They have,
Why don't you go to the tribunal?
my lord, they have taken out a surface proceeding.
What is your cause of action for challenge?
My lord, my cause of action for challenge is my 26D property was attached.
You are in no way connected with the loan.
My lord,
I am not.
Mr. Tiwari, you are in no way connected
No,
with
my
the
lord.
loan.
My lord, what happened
Go
was,
before the tribunal. Why don't you go before the tribunal?
my lord, 45 days have expired. My lord, and there's a judgment, my lord. I, being a third party, not the borrower, I have not taken any loan. The property 26E.
Third parties
Will-
are also permitted to go under section 17.
my lord,
What are you
third
saying?
parties are, my lord, but 45 days limitation is there.
So that
No.
cannot be bypassed by a writ petition,
No,
definitely.
my lord. May I, my lord? Panting for breath, my lord. Just 30 seconds, my lord.
No, take that time.
No, my lord. What has happened, my lord? I can go under section 17. There's a judgment of 2014, my lord, which says Article 227, 226 is maintainable. Be that as it may, I am not joining issues. I am just wanting one particular amnesty from my lord. The section 14 direction by the learned magistrate for attachment of the properties, which was not even mortgaged, because the statement of affidavit of asset in that my property was not disclosed by the bank. The deed have not been mortgaged with the bank. But as a matter,
You say your property is not even a secured asset.
no, I can show it to you from my lord from the affidavit of the bank.
Show me that.
My lord will kindly come to page 69 of my lord's brief.
Yes.
My lord will kindly see item number 9 in that list of original documents.
9.
My lord will kindly make a note of the deed number. Item number 9, deed number, last but one line being number 04043.
Yes.
Date is 2013. Now, my lord will kindly come to page 48. That is the portion of my deed by virtue of which I procured the property. 48, my lord. My lord, the deed number 05895.
The property description also has to be same.
Yes, no, my lord. My lord will kindly see it is not description.
The
Why?
same property was transferred.
No, my lord. 26E and 26D.
These are factual questions.
But I am not on facts. Perverse, my fraud.
That is dependent on the identity of the property.
My lord, what I
could decide that.
My lord, may I, my lord? What amnesty I am wanting from my lord? For now, this particular notice was affixed on my door on 21st of November. The order under section 14 admittedly has been passed in the month of October. 45 days have passed. Now, where lies my remedy? Unless my lord gives me that amnesty. Otherwise, what is happening? If my lord kindly sees the order passed by the learned magistrate, that is at page 59. I am not on anything else, my lord. Where there is right, there is remedy. Here I have right, but I am not getting any remedy. My lord will kindly come to page 59. The order has been passed on 4/10/2023. And when it was affixed, if my lord kindly comes on that when I got it, that affixation is at page. My lord will kindly bear me for a moment. That is at page 54. Page 54, my lord has got it. $54 million. 54, 21/11/2023. So, my lord, where lies my remedy? Now, my lord, what I'm humbly submitting, my lord, a very innocuous press, subject to what I have also spoken to my learned friend, because he is also akin that something wrong is there, my lord. And, my lord, if I go before the DRT, I will be having a remedy, and maybe I have very.
How many days?
My lord, 1 month, because ensuing vacation is there. Vacation is there, my lord.
DRT closes when?
My lord, on the 22nd, of course.
Today on the 1st. Go tomorrow. You are in a hurry. DRT is not in a hurry.
No,
sir.
My lord,
whatever
falls from my lord, 15 days.
Fortnight has fallen.
15 days, my lord?
No.
15. My lord, he's
1 day less. Fortnight means 1 day less than 15 days.
15 days, my lord.
Learned counsel for the petitioner argues that although an order under section 14 of the SABYASACHI Act, yes, I am passing that order. I am sorry, I returned. Although an order under section 14 of the SABYASACHI Act was passed on October 4, 2023, in respect of the petitioner's property, the notice under an action under the said provision was only affixed on November 21, 2023, which is beyond the 45 days contemplated in the statute, full stop. Next para, the petitioner argues that the property sought to be attached is the petitioner's property and was never a part of the secured assets. So as such, the entire SABYASACHI action is vitiated vis-a-vis the petitioner's property. Next para, however, due to paucity of time, it is submitted that the Debts Recovery Tribunal could not be approached. The petitioner seeks a leave to approach the said tribunal. and an interim protection in the meantime. Full stop. Heard learned counsel for the parties. Full stop. Since no affidavits are directed, comma, it is deemed that none of the allegations made in the writ petition are admitted by the respondents. Full stop. In view of the innocuous nature of the prayer, comma, however, comma, the matter is not intended to be retained further on the list. Full stop. WPA 26800 of 2023 is disposed of by restraining the bank from respondent bank from taking any coercive action against the petitioner on the basis of
Petitioners, my lord.
petitioners on the basis of the order dated October 4, 2023, passed in connection with miscellaneous case number
Case number 149 of 2023.
149 of
2023,
2023
my lord.
under section 14 of the SABYASACHI Act till December 15, 2023 or until further order which may be passed by the appropriate tribunal if so approached. Full stop. Next para, the petitioner shall in the meantime approach the concerned debts recovery tribunal with an appropriate application under the said act seeking interim relief as well. Full stop. If such application is filed by December 5, 2023, comma, the same will positively be taken up for the purpose of deciding ad interim prayers.
My lord, can my lord make it till 8th, my lord?
No.
My lord,
By December
my lord will make it 6th, my lord.
by December 12, 2023.
Indebted, my lord.
Full stop. The next para, it is made clear that the merits of the matter has not been gone into and it will be open to the tribunal to decide all questions including at the interim stage as well as at the final stage without being influenced in any manner by the above order. Full stop. No arrest to cause urgent certificate copy. By December 5 যেটা বললাম December 6 করে।
I am indebted, my lord. I am indebted.
I'm grateful, my lord. With my lord's claim.
Yes, next.
Item 5.
5. Yes, what is the matter?
And for the bank, my lord.
Bank, yes. What is
Serve your lordship the copies.
5, 6 and 7.
Yes, sir.
What are you, the muscle man of the bank?
Actually, the writ petition, your lordship, I have filed, your lordship, because your lordship on 28th November, they, your lordship, published an auction notice in their official website for
28th November, you said?
28th November.
Right.
And I came to know on 29th, and they scheduled the auction on 30th. The first and foremost, no proceedings, your lordship, no initiation has been taken under any SABYASACHI Act. So therefore, your lordship, I cannot go to DRT.
You are the borrower.
I am, your lordship, the co-borrower and the personal guarantor.
But the private respondents?
Private respondents, your lordship, are is the company in which I am the director, and 6 and 7 are also, your lordship, the directors of the company. 6 is not a director, 7 is a director. And your lordship, the dispute, your lordship, is between the inter se dispute between the directors of the company. May indicate what happened.
You are also a director.
I am also a director.
Director and a personal guarantor.
And as a personal character. May I, your lordship, once.
What have you challenged here?
I have challenged, your lordship, the purported auction, your lordship, which they are doing for sale of the vehicle of the company.
What is the ground?
The ground, no notice has been given. 2 days notice, no notice under the SABYASACHI Act 13.2, 13.4, nothing has been given. Only the NPA notice has been given it to me. And on 20th November, they issued a notice. The 30th, they are going to sell.
Issue a notice to the company was the borrower.
Company was I am the co-borrower. They have given me the NPA notice. Your lordship kindly sees the NPA notice once, page 87.
In your personal capacity?
Yes. Page 87, your lordship.
Maybe in the capacity of a personal guarantor.
Yes.
That does not entail to a separate notice for auction sale.
And your lordship, I am the co-borrower. My name, your lordship, is already in the vehicle loan agreement.
As a co-borrower?
As a co-borrower.
You and the company are co-borrowers?
Me and the company. Your lordship, kindly once, your lordship, let's see your lordship page 23 once.
Yes, show me that.
Page 23, your lordship, is the sanction memorandum, page 23, 4th September 2020. My name, your lordship, will appear at page 24. Page 23, clause B, details of the proprietor of Niji. My name is mentioned Shantanu Bhaduri as a director. Page 24, clause number 8. Co-applicant personal guarantee, Mr. Shantanu Bhaduri.
You are an applicant for the company.
No, your lordship, I am the co-applicant as well as the personal guarantee. That's why, your lordship, the NPA notice has been given it to me.
Yes, what do you say to this? 2 days.
My lord, he has himself given the possession of the vehicle. That is, my lord, voluntary surrender of vehicle and extra P2 page 28.
I have
He has
annexed to the-
himself handed over the keys and
Yes.
moreover we have followed
Maybe,
the
but
procedure.
Maybe he has handed over. We don't know under what circumstances someone
My lord, the auction
voluntarily hands over a car.
auction notice was given. The auction notice was given.
Auction notice should have been at least 30 days for him also.
15 days time we had given after the publication, my lord, of the auction notice. 15 days time were given to rectify so that he may come forward and pay back the loan. That he did not do. We held and already the vehicles are sold, my lord. Yesterday the auction was held. The vehicles have been sold also.
Page 88, your lordship, kindly come.
If the vehicle has been sold, then what can be done? One vehicle or several?
Two vehicles.
Two vehicles.
They have been sold. There is the submission.
Repeated reminders were
Then,
given them.
then nothing can be done.
No, only one thing, your lordship. I have also challenged if the sale has been done, your lordship, it should be held as illegal.
My lord,
Go before the tribunal.
Lordship, no, lordship, kindly appreciate. If they have given me 13-2 notice, 13-4 notice under the security interest rules, I understand. I would have given. Where is the notice? Lordship, kindly see page 88. If you keep the notice in your pocket, your lordship, that is not
no,
a
my
good
lord, the
notice.
notice was served on them. And then
Where
15
is
days
the
time was also given. Now, my lord, section 13, clause 8, subsection 8 of the SABYASACHI Act that states that he should have come forward before the issuance of the public notice and rectified whatever money and defects are there. That notice was there. He did not do all that. So accordingly, the auction was held on 30th yesterday. We got the bidder. We recovered the money. The vehicles have been sold. And these private respondents are also keeping tight.
You can entertain the writ petition on the disputed questions, but no interim order can be granted.
Only one thing, your lordship, kindly take page 43 once. What
even the borrowers,
why they have done, your lordship, I am
whatever maybe there is, I'll entertain your application, but I'll not grant an interim. There is no scope of an interim because the subsequent purchasers are not parties. I'll direct you to implement them. They'll inform you the names. But as of now, no interim order can be passed for interim order.
And sales certificate also.
What about no 13 for action having been taken out?
My lord, I have given them notice. MPA notice was 31st/10/2023. Then this reminder notice was on 14/11/2023.
Can there be an auction sale without section 13 being resorted to? Tell me that.
Must have been done, my lord. I have followed all because yesterday I received this brief,
When
my
a counsel for the petitioner makes out a strong prima facie case as to the writ petition being heard on the ground that allegedly no action under section 13(4) of the SABYASACHI Act was taken out against the petitioner, who is a co-borrower and a personal guarantor in respect of the two vehicles concerned, full stop. It is submitted that only on short notice of 2 days, the vehicles were scheduled to be sold, full stop. As per contention of the petitioners, the notice was given on November 28, 2023, and the sale was scheduled on November 30, 2023, that is yesterday. Full stop. Next para. Learned counsel appearing for the bank controverts the allegations made by the petitioner and submits that the sale has already been carried out yesterday, and the bank has recovered the dues. Full stop. It is submitted that the bank duly gave notice with a gap of 15 days as per the statutory requirement. Moreover, the petitioner himself did not contact the bank at any point of time. Next para. Thirdly, it is argued that the bank resorted to due proceedings under section 13 of the SABYASACHI Act. Next para. In view of the petitioner having made out a strong prima facie case for hearing on the above grounds, the writ petition is required to be heard on merits. However, since the bank contends that the sale of the vehicles has already been effected in favor of third parties, it would only be appropriate if the said parties are also included and given a notice of the hearing. Accordingly, the learned advocate for the bank shall communicate the names of the purchasers to the learned advocate for the petitioner by December 4, 2023. The petitioner shall thereafter implead the said purchasers The learned advocate on record for the petitioner is granted leave to carry out the necessary amendment to the cause title of the writ petition by December 5, 2023, implementing the said purchasers. The petitioner shall thereafter give notice of serve copies of the writ petition on the added respondents immediately thereafter and file an affidavit of service to that effect on the next returnable date. The bank shall file an affidavit the respondent shall file their affidavits in opposition within a fortnight from date. Reply, if any, shall be filed within 3 days thereafter. The matter shall be listed under the heading upgraded matters on December 21, 2023. Come back.
In the meantime, you should let them not transfer the name.
I cannot do that because the
Before the
purchasers are not party. That is what I said. Unless they are implemented, I cannot pass any restraint order on them. They are the owners now.
No, they are.
Come back on 21st. I have kept it before the vacation as an exception.
Yes. Hard copy সাফ করবে রাজীব মল্লিক করেছে তো
Upgraded matter. Item 6.
Yes, Mr. Dattu.
Lordship was hearing this. Mr. Chaudhary was addressing this.
Yes, right. Yes, Mr.
Lordship, preliminary objection had been taken on the yesterday occasion. If your Lordship sees, I would be in a position to develop it a bit further for your Lordship's consideration if your Lordship so feels.
Well, I was in midst of my argument, my lord. Mr. Mitra has already done it. Why again?
You won't be developing anything. You will be arguing only on the points, Mr. Yes.
Well, the writ petition is challenging a letter of the competent authority. That is the limited scope. Now, well, why the competent authority and what is the scope of challenge? Well, the competent authority is under the West Bengal Apartment Ownership Act. What was the role of the competent authority and why the competent authority was involved in this election process? My lord, Lordship will recall the main issue is involving, my lord, elections of, my lord, the Residents Association of Elita Garden Vista. A civil suit was filed, which according to us was a collusive suit, my lord, where, my lord, the special officer was appointed and, my lord, an in-house election was sought to be done. Against that, my lord, we come up in appeal. Initially, the appellate court passes the order appointing an independent special officer. Initial observation was Tower 8 residents will not vote. Then, my lord, it goes up to the residents of Tower 8, challenge it in Supreme Court. My lord, they give them the liberty to, my lord, file an application before the appellate court. Kindly straight away come to the appellate court's order, which starts at page 160. Lordship will get the entire background. That is why I am coming to this order. This order is important because, my lord, this is the reason why the special officer was directed to consult the competent authority.
Mr. Chaudhary, is the entire order necessary? That was the context of the suit.
Only relevant parts I issue.
The competent authority, the competent authority was asked to aid the special officer.
Yes, no. That the order which was shown by Mr. Mitra, my lord, under the garb of maintainability, that is not. Kindly, my lord, kindly come to this one. 17th March 2023. This is the background. Lord, kindly comes to page 161.
Yes.
Well, this is the order of the Supreme Court. At the bottom, vacating and modification. Then, my lord, kindly comes to, but since my lord wants to see the operative part after the submission 180.
Yes.
Second para. When we passed the order, the applicants were not heard. The applicants are 22 in number out of 160 owners of the newly constructed Tower 8. We proceeded primarily on the basis of order passed by Justice Boshak. We were.
Who are you, Mr. Chaudhary, among these array of parties?
I am the Residents Association.
You're the association.
In the appeal, I was the appellate.
Yes.
We accepted the argument of Mr. Shah. We accepted the argument of Mr. Shah that the order passed by us insofar as it affects the right of present applicant is beyond the scope of the suit. Whether the applicant, this is very important. Whether the applicants can be considered as owners within the meaning of Section 3IA of the West Bengal Apartment Ownership Act was not considered when we decided the said appeal. This point was never urged nor argued. The applicants have disclosed title deeds, which prima facie establish they have purchased the flats. It is not necessary for us in this proceeding to decide if by reason of such deed they would be entitled to participate in the election. Well, this is vis-a-vis section 3(1) IA, because well, you have to be building, then apartment, then owner, well, it is coming in. The parties have already disclosed proceedings before the competent authority with regard to objections concerning Form A and Form B. So, my lord, objections, well, there before the competent authority, my lord, rejected the application to modify Form A by incorporation of the 8th tower, tower number 8, 16th tower. That was rejected. This is not the subject matter of suit, nor a matter was urged therefore before us when we restrained the applicant purchasers of flats in tower number 8. The orders relied upon by Mr. Chaudhary that were passed in the pending writ application would not show that the present petitioners were debarred from exercising their rights under the respective deed of purchase, nor the issue as to whether they would be considered as owners under the Apartment Ownership Act was gone into and decided. It appears the competent authority is in session over the matter. Under such circumstances, we are of the view that the sentence, the flat owner of the newly constructed tower, however, should not be included in the electoral list in view of the pending litigation, needs to be deleted as it is beyond the scope of the suit of the appeal. We make it clear this order shall not be construed as an expression of opinion with regard to the claim of the applicants to participate in the election as owners of respective flats. The order is recalled to that extent only on the ground that the said issue is not the subject matter of any litigation and is beyond the scope of the suit. So, my lord, appellate authority made it clear that competent authority is in session of the matter. We are not expressing anything. And whether they can be considered owners solely on the basis of the deed
for the purpose of being on the electoral roll,
or
that was left open.
That was left open, and my lord, competent authority. Now, in this background,
yes,
Lordship will see, my lord, the next order. When the special officer, my lord, kindly see, my lord, the minutes of the interim report of the special officer, page 222.
Yes.
এটাই তো 70, এটাই 70, যেটা পড়লাম সেটাই 70.
Are you challenging this?
No, I am showing, my lord, when the special officer holds a meeting,
yes,
kindly see, my lord, 222. I am not challenging this.
What are you challenging ultimately? Just let us start from there. I mean,
my lord, the report of the competent authority.
Very well. Subsequent report of the competent authority.
Yes, 248, I believe.
248.
Sorry, 276.
Yes, right. Very well.
Let's straight away kindly come to para 4. In the said meeting, certain points that were to be discussed in connection with the meeting held between the special officer and the competent authority, hearing not concluded. In the said meeting, parties put forward their submissions with regard to objections, observation, comment with regard to the meeting held between the special officer and competent authority. Special officer, after giving considered hearing, requested the parties to file the written notes. Then, my lord, the submissions of the on behalf of my clients, my lord, recorded by the special officer.
Special officer is not a party to this writ petition.
No. Then I am also not troubling your lordship. Submissions on behalf of 226 lordship will kindly observations.
Yes.
I have carefully considered the submission made on behalf of the parties. Division bench observed as follows. The relevant portion has been quoted by the special officer. From the observation of the page 227, para 8. It is clear whether the applicants, now kindly see the issue frame, whether the applicants can be considered as owners within the meaning of section 3(1)(a) of the Act was not considered while deciding the appeal. Neither this point was argued nor ever urged. Applicants have disclosed title deeds which prima facie established that they have purchased the flats, and thus division bench proceeded to delete the portion where it directed the new tower, tower 8, and owners thereof should be included in the electoral list. It was further observed by the division bench, competent authority is in session of the matter and special officer is directed to proceed in consultation with the competent authority. In terms of the orders of 15th and 17th, the special officer did hold a meeting wherein modalities were outlined. However, at a very belated stage, the appellant has raised concerns with regard to participation of owners of Tower 8 in the situation. As a special officer, it is a tricky situation for me to opine whether to allow or disallow any such objection raised. Then we'll straight away 228, para 12, last sentence. Although the competent authority and the special officer did hold a meeting and did outline the modalities for holding election for the interest of justice, it is best that the matter is referred back to competent authority so that competent authority may take a decision with regard to the impending issue and advise the special officer accordingly. And well, it kindly comes to page 214 for a moment. This is, my lord, the minutes of a meeting between special officer and competent authority where no parties are present. And my lord, this has been issued only by the special officer. So after this, when we point out to the special officer, he agrees, he refers it back to the competent authority, you decide the issue. Now kindly see, my lord. 276. At no point of time, the competent authority decides the issue that whether, vis-a-vis the observation of the appellate court or the dispute in question, whether they are owners per se by their title deeds or they are treated to be owners under section so and so of the Apartment Ownership Act. Now kindly see competent authority. With respect to the above mentioned subject, I am in receipt of your letter which was sent to my office via email 26 September. In this context, I would like to inform you. Well, our letter was, my lord, raising all these issues and asking the competent authority to decide. I would like to inform you, I had received interim report of special officer on 19 September. In terms of the report, I had already communicated to the special officer by a letter of 21st September, which was sent by post, that in terms of the meeting of 16th August, that is page 214. When, my lord, after that, the special officer has, my lord, sought a clarification when we raised the issue. The decision was arrived at 16th August, special officer should proceed with the election of the association. This decision was arrived at pursuant to the observation of Honorable Division Bench that the competent authority is in session of the matter. Since the competent authority has already suggested the special officer about the mode, this office feels special officer should proceed with the elections of the association without further delay. Every flat owner is a member of the association as per provision of Ownership Act. Therefore, in the present case, election should be conducted with 1551 flat owners. That is, my lord.
So you say virtually by this, the competent authority decided the issue without deciding it.
Decided the issue, firstly, without considering any of the issues raised. And my lord, this is just that. What is the reason? Reason is I had in August communicated to the special officer that you go ahead with the election.
The best relief you can seek, Mr. Chaudhary, is apparently that this should be set as
only, my lord, I am
directing the competent authority to
why
decide.
my learned, yes, that's the best relief. Why my learned friends are, my lord, arguing this? All I am saying is kindly ask the competent authority to decide, hear it and decide it in 7 days.
Afraid of Mr. Dottu. They are afraid of Mr.
No, my lord, no question of afraid, my lord. Either, my lord, they are entitled or not entitled. There is no dispute, my lord, that they have.
No, I get your video.
Only competent authority in 7 days. The competent authority will say this is the reason.
So you say that page 247, 248 should also be read in the context of this.
Yes,
I mean, the previous observation.
My lord, the special officer, regarding modalities of election, we have no issue. The only issue is electoral list. The division bench made it clear that the competent.
No, the page 248 says the special officer in consultation with the competent authority shall prepare an electoral roll, which necessarily involves a prior decision on what should be the electoral roll.
Correct.
Should come.
And my lord, the 248, the consultation with the competent authority was only with regard to Tower 8 in the background of the division bench judgment. In the background, one line of 248, if I read it again.
Yes, please. But the next sentence says the flat owners of the newly constructed tower should not be included in the electoral list. That is also there.
No,
But your
that
grievance is regarding
that
the
is, my lord,
other.
my lord, flat owner should not be, that was, my lord, this is the parent order. I showed your lordship the modification after that.
So the competent authority, according to you, must decide whether the subsequent purchasers who had applied, those applicants, their electoral roll name, their
My lord, this
that
portion,
should be decided.
this portion of the order, my lord, kindly come back. This is the parent order. I made a
Yes.
mistake. I should have
Yes.
placed it here only. 248, kindly see. This is the order which was modified. This line is not modified. The special officer, in consultation with the competent authority, shall prepare a electoral roll and decide on the mode of voting. The flat owners of newly constructed tower, however, should not be included in the electoral list in view of the pending litigation. Only this line was modified to the extent I read to your lordship.
Yes, the rest remains.
Now,
the previous applicants, whether they should find place in the
correct.
electoral roll, that has to be decided.
Yes, and that has to be decided, my lord, whether the deeds per se, my lord, if the competent authority holds deeds per se, they are owners. Or, my lord, under section 21A, my lord, they are not owners or owners, whatever it is. One decision from the competent authority. Otherwise, my lord, what is happening? If a tower is not recognized till date, my lord, at the cost of repetition, I had repeated it on the last day. If a tower is not recognized in the form A and the tower comes up, who is the person who will decide whether the occupants legal or illegal? I am not on that. That is not the scope. Who will decide, my lord, whether they are owners within the meaning of Apartment Ownership Act?
Mr. Chaudhary, answer one question. The page 180 you placed before me. Certain applicants were there who had raised an objection.
Yes, 22, my lord, the court has 22 applicants of Tower 8.
22 applicants. Those 22 applicants are of Tower 8 only.
All Tower 8.
Achha, how do you propose to go about it? I mean, page 248 says, the next sentence says, shall prepare an electoral roll. The flat owners of the newly constructed tower should not be included in the electoral list in view of the pending litigation. So how do you reconcile? I mean, therefore, before
this was the original order. Against this order, the flat owners of Tower 8 went to Supreme Court saying that we were specifically not, and this order was passed when the promoter was there.
The page 248, this line does not remain now. That the owners
248. Well, kindly come to page 181.
248 is a 22 order.
Well, that is why, Mr. Mitro showed the parent order, but the modification part was not.
Oh, page 248 is the previous order.
Yes.
It's the, I mean.
My lord, initially the appeal court, my lord, it upheld that, my lord, it was of the view that they should not be. But because the flat owners came and the only grievance was that this is not the scope of the suit, and that the division bench said, all right, I have page 180, I have shown to your lordship, my lord, that was struck out.
181
and my 181 lordship will come back, lordship will get that. 181, I read the third para. Under such circumstances, we are of the view that the sentence, the flat owners of the newly constructed tower, however, should not be included in the electoral list of pending litigation, needs to be deleted as it is beyond the scope of the appeal. We may.
No, you're right. I was proceeding.
And the division bench makes it clear. We make it clear, order shall not be construed as an expression, appellant participate in election and owner.
I was thinking this was the previous order.
No,
Now
that was the impression given. That is why, now, 214, the meeting between the special officer and the competent authority.
No, you said after that the special officer wrote that, no, I am still unclear.
My lord, after this order, when, my lord, 214 lordship sees.
And that minutes, that meeting cannot be an adjudication. I mean.
Yes, my lord, the 214 is, my lord, modalities they are discussing, my lord, 16th August, my lord, 214 it starts. Lordship will find 216. In fact, my lord, 215, para 2, entire owners list is required for preparation of a members list, para 2. Then, my lord, 216, para 11, conferment of necessary incidental powers to be given to special officer duly appointed to conduct election of 1511 flat owners.
So that does not say anything about the debt.
Nothing. And, my lord, when we raise the issue and the special officer says that I am remitting it back to the competent authority for this, it's a tricky situation, I am not empowered to decide it. The competent authority refers to the earlier meeting of August and says, I have already directed, so you go ahead. And
This is, my lord, this is the scope of it. This is the scope
Let
of
me
it.
hear that. Yes, yes, Mr.
My lord, I must also indicate to your lordship that so far as the other writ petition is concerned, in the meantime, the NKDA writ petition, my lord, where we had asked for the challenging the
That is also
sanction,
appearing today.
sanction plan. No, that has been disposed of. My lord, directing NKDA, my lord, to again give a fresh report vis-a-vis the violation of the building code and all that. And against that order, my lord, the Apartment Ownership Act contention which we had
That is
raised.
regarding this one. This
No, this same building. I am just bringing it to your lordship's notice that has happened in there. But has that nothing to do with the election.
Yes, Mr. Mitra or Mr. Shah, whoever.
Mr. Shah, I sold my flats and I have gone.
You are for those applicants.
No, I'm for the developer. I was.
Mr. Shah is for those applicants, by 22 applicants.
So let him make his submissions first.
Who is for the competent authority? Competent authority is a party here.
Yes, competent authority is the main person.
Competent authority is sitting behind. Yes, Mr. Shah first. Yes.
But there are in fact much more than the total 29 what that was of the tower rate. Tower rate constructed upon receiving an appropriate sanction. Well, building constructed over the years. Well, flats sold, value paid, flats are in occupation. Then, my lord, my learned friends, my lord, come up in appeal against an order passed in a suit, my lord, where the Tower Rate Association residents are not a party. My lord, they obtain an order from, my lord, the division bench, my lord, that election should be held without, my lord, the participation of the residents of Tower Rate. Although that was not within the scope of the suit at all. My lord, the Supreme Court directs the matter to be reconsidered. The court, my lord, holds that yes, this is not within the scope of appeal. And hence, my lord, deletes the portion in the order which says that, my lord, Tower Rate Association residents will not be able to participate. Now, my lord, so far as that is concerned, with the greatest of respect, my learned friend cannot place any reliance on that part of the order at all. Because, my lord, that part of the order, including the observation made in that order, that, my lord, this matter will not prevent the my lord, competent authority to decide, my lord, completely beyond the scope of that suit itself. But, my lord, be that as it may. The question is, what is my learned friend's contention? My learned friend's contention, my lord, in the other NKDA writ that my learned friend refers to, is that, my lord, you could not have even applied for sanction of, my lord, the plan for Tower Rate without the consent of the other residents of the association who have become flat owners. Because they say that we have now crystallized what is our undivided share in, my lord, the rest of the property, common areas, etc. Now, my lord, my learned friends yesterday filed a supplementary affidavit with your lordship's leave. My lord, that supplementary affidavit, my lord, mentions that, my lord, the order has been, writ has been disposed of without, my lord, showing your lordship the order. My lord, that order decides on this issue.
No.
My lord, it says that, my lord, the Apartment Ownership Act, my lord, cannot give you the right to, my lord, come and contend that without your, my lord, concurrence plans could not have been submitted. I shall show your lordship that judgment. My lord, so therefore it says that it is none of your business as to whether the developer had applied for sanction of Tower Rate without your concurrence or without your consent. Now, my lord, that part is over. What is my learned friend now saying? That although the tower was constructed, my lord, on sanction obtained, my lord, without their participation, which was not necessary. My lord, today you can't recognize them to be owners, although they have, my lord, a registered deed of conveyance. They have paid valuable consideration. They're in occupation. They are, my lord, in fact, participating in paying of maintenance charges, common area expenses, everything. Now, my lord, if they are paying common area expenses, well, the question is, my lord, should they be allowed to be a part of the association, my lord, whose sole function is to, my lord, ensure the upkeep of, my lord, the apartment, my lord, that we are concerned with. Now, my lord, my learned friend says that Form A is sacrosanct. Form A, once filed, my lord, cannot be changed. My lord, with the greatest respect, that point is dealt with. My lord, in the judgment, my lord, of the...
Let my learned friend show that.
Yes, yes, I shall show you, lord.
So you are saying that nothing remains to be decided on that by the competent authority?
That's it, my lord. Now, my lord, kindly see, my lord, so far as my learned friend is concerned, he says he does not, my lord, dispute the fact that a person who, my lord, becomes an owner of a property by virtue of a conveyance is entitled to be, my lord, an apartment owner within the, my lord, purview of the definitions of apartment owner in the Apartment Ownership Act.
Yes,
and hence, my lord,
if the merits of the matter has not been decided, this writ petition does not concern the merits of that, whether you are entitled to come on the electoral roll.
Right.
I mean, he does not bring that within the adjudication of the court. If it has been decided already, that's a valid point which you can take.
Let me show you, lordship, that
I think that will be easier.
Judgment.
So should I look into their supplementary affidavit?
No, well, that supplementary affidavit, well, there's only said it's reserved for judgment. But well, the fact that the judgment has been delivered, if your lordship kindly sees page 30 of the supplementary affidavit. Well, this
Have you got a-
says,
yes.
the portion of the order which says reserved for judgment.
Where will you have handed over the judgment?
Yes, sir. Now, well, kindly have a look at, well, the judgment. I shall take your lordship only to the relevant provisions. Kindly have a look at, my lord, page 2. Well, at paragraph 2, Roman 4. Well, this, my lord, makes a reference to, my lord, the West Bengal Apartment Ownership Act and rules. Well, let me not, my lord, waste your lordship's time. Well, after that, your lordship will kindly. Well, let's see, my lord, there is, my lord, reliance placed by my learned friend on, my lord, the Supertech, my lord, building. Well, let's kindly have a look at paragraph. Yes, well, paragraph 4, I'm sorry. Well, at Mr. Chaudhuri, my lord, learned senior advocate appearing in support of the writ petition submitted that the registered apartment owners are co-owners of the project, and the sixth respondent, by suppressing the aforesaid fact, obtained sanction to the revised plan by claiming to be so known. He submitted that the open spaces and indicated in the original sanction plan could not be utilized for construction of Tower 8, as that would amount to alteration of the percentage of the undivided interest of each apartment owner in the common areas and facilities as expressed in Form A declaration. Similar reference is made to Form A declaration. In support of such contention, Mr. Chaudhuri placed reliance on Section 5 of the 1972 Act. By referring to various clauses of the deed of conveyance of such and such, Mr. Chaudhuri contended that the provisions of 1972 Act read with 1974 rules shall have application to the case on hand, and the sixth respondent was obliged to follow the said provisions. He, well, the sixth respondent is developer. He contended that the registered apartment owners are owners in relation to the property, which is the subject matter of this project in view of Section 3(1)(a) of the 1972 Act, and therefore an application for sanction of the revised plan could not have been submitted without the consent of the registered apartment owners who have become co-owners of the property. Advocate further contended that the sixth respondent attempted to amend Form A declaration by filing the revised details in Form B without seeking the approval of the registered apartment owners, but upon an objection being raised by the registered apartment owners, competent authority under 72 Act rejected Form B by an order of 11th April 2018. Mr. Chaudhuri contended that the declaration made in Form A is required to be preserved. Well, this is a specific contention, and consequently the revised sanction plan is liable to be cancelled, being contrary to declaration in Form A. He submitted that since the 1972 Act is binding upon the sixth respondent, sanction to the revised plan could not have been obtained. Then, well, if your lordship kindly sees, well, at paragraph 8, well, at Mr. Mitro's submission on behalf of the developer, at page 6, well, at fifth line from the top of the page, he submitted that the apartment owners had consciously waived the benefits of the 1972 Act, as would be evident from the terms incorporated in the deed of conveyance. Well, they had agreed that you may develop and further towers and sell. Then Malad will kindly ignore the discussion.
This is all submission, not finding, with respect. Till para 50, it is all submission.
Well, these were the matters that were drawn to the court.
Yes, I want, let my learned friend substantiate where it has been decided.
Paragraph 31. 31, my learned friend sought to refer to the UP Apartment Ownership Act, on which Supertech had proceeded. This court held that that has no application. Then 33. In the West Bengal Apartment Ownership Act 1972, there is no such provision which is parameter with Section 4 of the UP Apartment Ownership Act. Then 35. Then it 34, I'm sorry. On the this is the provision of our Act. On the contrary, by virtue of Section 184, the 2007 Act shall have an overriding effect of other laws. This is the Newtown Kolkata Development Act. Then, learned advocate for the petition in the course of his argument could not point out any provision in the 2007 Act restricting the power of the promoter to make any alteration in the plan specifications and other particulars after execution and registration of deeds of conveyance in favor of apartment owners. In the absence thereof, this court is of the considered view that the provisions contained in the 72 Act prohibiting the alteration of the percentage of undivided interest of each apartment owner in the common areas and facilities as specified in Form A declaration cannot prevail upon the provisions of the 2007 Act. Now, this is the finding. So, my lord, you can, my lord, apply for and construct, my lord, more, my lord, apartments if that's permitted by the laws, municipal laws. Then, my lord, the bottom of, my lord, this paragraph, this court accordingly holds that the provisions of the 1972 Act do not have any consequences on the right of the promoter to obtain revised plan.
Yes.
Therefore, the issue of taking consent of the apartment owners while submitting the application for revised plan does not arise in this case. Now, my lord, if this, my lord, is the finding, then, my lord, if the sanction was duly obtained, if the building was duly constructed, if the apartments were duly sold, if value was paid, and, my lord, these persons are now participating in the maintenance, my lord, because they are not paying maintenance charges, common area expenses, etc. Then, my lord, how can they be excluded from, my lord, the...
Mr. Shah, that is a deduction which has to be drawn, but the deduction has not been drawn or any decision has not been taken on this. I mean, this was, yes, consequentially, you may say that argument becomes valid, whatever you are arguing. But those are deductions which had to be crystallized in the way of an adjudication on this, that whether you are entitled
Now,
to.
so far as the adjudication
That has
is
not
concerned,
happened.
well, that adjudication, well, where is that adjudication to happen? My learned friend says that adjudication is to happen in favor of the order of the division bench.
Yes, the division bench said so, and you have not challenged that.
No, well, so far as division bench is said, the competent authority will decide. Now, my lord, the competent authority's decision, my lord, does not have to, my lord, really a decision, my lord, which spells out, my lord, the fact and the law and the discussion on the subject. It has,
A single line of reason has to be there.
Well,
there's no reason, absolutely. I mean.
Well, the only thing is, well, if your lordship sees, my lord, the Apartment Ownership Act, well, I can take your lordship to the act. Well, your lordship is, my lord, now of the opinion that, my lord, he was adjudicating. My lord, there is nothing really to adjudicate. My lord, all that I'm saying is, my lord, if this is, my lord, an adjudicatory process, then, my lord, of course, persons will have to be heard. Views have to be taken, orders have to be reasoned orders passed, my lord, expressing an opinion on, my lord.
Not adjudication in the sense of a judicial adjudication, but a decision has to be taken by the competent authority, even as per the division bench's direction. Observation.
They've taken a decision. My lord, saying, my lord, kindly see what is the decision. Kindly see page 276.
Yes.
My lord, that is all, my lord, respectfully, that is required to be done. My lord, kindly see. Well, this is the point. Every flat owner, last line. Every flat owner is a member of the association as per the provisions of the West Bengal Apartment Ownership Act. Therefore, in the present case, election is to be conducted with 1511 flat owners. My lord, what more is required? I respectfully ask myself. Now, my lord, if the sanction is valid, if the construction is valid, if the sale is valid, in that case, my lord, how can you be kept out? My lord, more than this, what is required to be said? Now, my lord, my learned friends, my lord, cannot now contend that, my lord, these are not, my lord, flat owners. My lord, they had tried to contend before, my lord, the writ court that, my lord, yes, this construction itself is bad, so they can't be recognized. They had referred to the Apartment Ownership Act, referred to the rules, and said that, my lord, this cannot be done. The court has said, no, your permission or your consent was not necessary, validly, my lord, sanctioned, thereafter validly constructed, flat sold. And, my lord, what is the conclusion? The conclusion is every flat owner, and I am a flat owner, is a member of the association as per the provisions of
Shah, can I see what is the provision regarding who can vote? I mean,
yes, my lord. Can you see the rules?
Let us go into that also once. Is the expression used owner?
My lord, if your lordship kindly sees, my lord, the rules. My lord, lordship will kindly see.
The bylaws.
My lord, this is the West Bengal Apartment Ownership Rules.
Rules, right? Yes.
I think, my lord, the disqualification is only therein. Well, first of all, my lord, my learned friend refers to Form A. I'm sorry, my lord, this is in the bylaws. My mistake.
Yes.
My mistake. West Bengal Apartment Ownership Bylaws. Now, my lord, first, if your lordship sees, my lord, formation of association, that is, my lord, section or rule or bylaw 3.
3, yes.
My lord, 3(1)(b), where an apartment owner transfers his apartment by sale, gift, lease, exchange, or assignment to any other person, he shall cease to be a member of the association concerned from the date of the sale, gift, lease, exchange, or assignment, as the case may be, and the transferee becomes immediately a member of the said association in place of the transferor. The transferor and the transferee shall notify such transfer to the board by writing a letter to the president, etc. When more persons, this is C, on which reliance was placed, where if more persons than one jointly own an apartment, such person shall nominate one of them to be a member. So, my lord, it is ownership, my lord, that is the basis. And, my lord, thereafter, if your lordship kindly sees, my lord, what is the disqualification? My lord, that is, my lord, regulation 11, bylaw 11. Well, the only disqualification is any apartment owner.
Yes. That is payment.
Well, any apartment owner who fails to pay in any financial year any installment of his contribution towards common expenses, which may have been assessed by the concerned association, shall not be entitled to vote at any election of the managers of the board to seek election for the office of managers. And, my lord, the Act, my lord, Section 3B, my lord, the definition of, my lord, association of apartment owners is important.
Yes.
It says, association of apartment owners means the association competent to contract in its own name and formed in accordance with the provisions made in the bylaw. Now, my lord, then, my lord, lordship kindly sees the definition of owner.
IA.
IA.
Yes.
Owner in relation to any property or part thereof, apartment includes any person owning such property or part thereof, etc. Any person deemed to be owning such property or part thereof, any promoter, any lessee, etc.
So it is not restricted to the initial owners.
No.
On the date of the election, whoever is the owner,
Yes,
can.
that's it. Because transfer, my lord, transfer immediately becomes the owner. By gift, sale, anything.
Yes.
So, my lord, if today, my lord, a transferee, my lord, that is a transferee from the developer who was, my lord, the initial owner, becomes the owner, my lord, he is entitled to become a part of, my lord, the owners association, and therefore entitled to, my lord, decide as to who, my lord, will form the board.
This is the first election. I mean, the formation of the association is happening now.
Yes, first election. And, my lord, kindly see, my learned friends are really interested in keeping me out. They say that, my lord, the owners of, my lord, apartments in Tower 8 should not be allowed to, my lord, participate in the election. That is the order that they obtained behind my back from the division bench. That is the order that was set aside. And, my lord, adjudication done. Now, my lord, adjudication, what has he to determine? The competent authority decides, are you an owner within the meaning of the act? If you are, then you have a right to vote. What more is required? What more adjudication does he have to do?
And 10A and 10B are the powers of the competent authority, apparently.
Yes, ma'am.
So there is no special adjudication involved in that.
That's right.
Regarding voting.
That's right. And he is, my lord, not really an adjudicatory authority. Well, he has to only see, are you an owner? If you're an owner, you're entitled to vote. Now, my lord, whether the building was duly constructed, whether the sanction was duly obtained, well, that challenge stage is over. And, my lord, my learned friends wanted really a declaration from the writ court by, my lord, saying that the Tower 8 could not have been constructed at all, saying that you are therefore illegal occupants of the Tower 8 and you have no right to vote. Then, my lord, the same approach was made to the division bench, my lord, behind the back of the Tower 8 Owners Association. And the division bench also ultimately deleted that portion of the order by which it said elections will
kept it open, kept it open to be fair to him.
But, my lord, this is the only what more? I mean, my lord, what more is sought to be expressed? Has to be expressed.
Yes.
Well, that is all.
No. Is competent authority? Why is competent authority hiding? No seat.
No. Well, may I have your lordship's leave?
Yes, yes.
Competent
Sorry, Mr. Mitri, you would like to add something? Oh, yes.
I'll let you.
Yes, yes, you clearly made it out.
That this is, I will show the documents, because then I open my submission, that this is not judicially reviewed. Because after all, the division bench in a civil suit said to consult. Consultation was a must. If the consultation did not happen, it would fall foul of the division bench order. Even then, one could not come to the writ court. But if the consultation happened, then in that case, the contents of the consultation, what the competent authority advised, is not judicially reviewed. Even if it was the highest, even if it was the consultation as per Constitution of India. not judicially reviewable.
So no adjudication.
No adjudication. The court cannot vest a authority under a special statute with power to adjudicate. That's why the division bench consciously did not give any adjudication power and said only consult. It
No,
was like
division bench in the last order said that is open. Competent authorities in season over the matter. It should
maybe
be
it's
said.
season over the matter, but what is the competent authority's role so far as this election is concerned? Maybe in season, if they get a decision under any of the provisions.
No, but the issue as to whether these people are to be part of the electoral roll.
Well, that
they are entitled to vote. That is what was deleted, and division bench opened it up and said it is kept open because competent authority is in season of the matter.
That was kindly takes a look at.
Although you may argue that even the division bench cannot confer jurisdiction where there is no jurisdiction. That argument remains.
That argument I will.
But apparently, division bench indicated that.
But Lordship, may I just show that first order first? The first order is at page.
First order has merged with the last order.
But whether that part is gone or not, Lordship kindly takes a look at page 240. I'm only at that 247 bottom.
Right.
247. Whether that part is gone or not. That's the only thing. And whether even then whether it can be.
Right.
Last 5 lines of 247. We are while we accept the finding of the learned trial judge that there should be a free and fair election. However, we are of the opinion that under the facts of the case, the special officer appointed by the learned trial court with the aid of the competent authority shall hold the election. The special officer in consultation with the competent authority shall prepare an electoral roll and decide on the mode of voting. This part, what he advises, is not judicially reviewable. If at all reviewable, it will be in the civil court. Or they could have gone up higher up in appeal. They do not go up in appeal from this order.
Right.
The Jishnu Chaudhury's client, some of the flat owners go up to Supreme Court and the matter is remanded back. I don't need to, Mr. Jishnu Shah's client. They go up and it's remanded back to the court. Lordship, I just come to the relevant part of the page 269, I think. 269 too. Page 269. Yes. Lordship, may I come straight away to last 2 lines? I'm going to operative part. The orders relied upon by Mr. Chaudhury that were passed on the petition would not show that the present petitioners were debarred from exercising their rights under the respective deed of purchase. Writ petition means that is the Justice Herma Bhattacharya's writ petition.
Neither debarred nor considered as owners.
That is Justice Bhattacharya's, where at the time it was pending. They would be considered. It appears that the competent authorities in season of the matter, over the matter. Under such circumstances, we have the view that the sentence, the flat owners of the newly constructed tower, however, should not be in the electoral list in view of the pending litigation, needs to be deleted. Now, let's
say even as per this order, what the competent authority was in season of was the ownership, basically, which has been decided by Justice Bhattacharya.
But I'm not going into that.
As per this order, I mean.
Yeah, but then that may be a right order, maybe a wrong order.
But that is different.
But then what is deleted is, Lordship will kindly interpose this order on page 248.
All right.
Just interpose this order. What goes away, it's very clearly within quotation that the flat owners of the newly constructed tower, that is at page 248, 4th line. So, in the court consciously did not delete the first 3 lines of page 248 nor the last 2 lines of 247. Deleted is the flat owners of the newly constructed tower should not be included in electoral. Just this one sentence, 3 lines at 240 has been deleted. We make it clear that this order shall not be construed as an expression with regard to the claim of the applicants to participate in the election as owners of the respective flats. The order is recalled to that extent only on the ground that the said issue is not subject matter of any litigation. Not the subject matter of any litigation. So, the first 3 lines and the last line of 247 and the first 3 lines of 248 have not been touched consciously by the court. Let's take it that the court was under the impression that that the competent authority is in season of the matter. But even then, the court did not let the competent authority to take a decision in accordance with the Apartment Ownership Act. He said this part remains in consultation. Now, Lordship kindly sees what was the decision at the special officers meeting. The special officers meeting, which is at page 222, which Mr. Chaudhuri placed. Kindly come to page 225, Roman 6. By appellant, it is Mr. Chaudhuri's client, who was possibly represented by some lawyer, I do not know. 225, at the top, Roman 6. In conclusion, the appellant submitted special officer may refer the matter to the competent authority, so that in consultation with the competent authority, the special officer may decide on the electoral rule. Consultation. That is exactly the division bench order. And then this goes on further to record. Lordship kindly turns the page to page 227. Paragraph 10. The word in season of the matter has paragraph 10. It was further observed by the division that the competent authority in season of the matter and the special officer is directed to consult with the consult. Now, kindly come to page 228, paragraph 13. It should be everybody's endeavor. Sorry, page 228. I have to show the first paragraph, fourth line, 220, fourth line from top. Although the competent authority and the special officer did hold a meeting and did outline the modalities of holding the election, for the interest of justice and convenience, it is best that the matter is referred back to the competent authority, so that the competent authority may take a decision with regard to the impending issue and advise the special officer accordingly. Consultation will lead to an advice. It should be everybody's endeavor that free and fair election is held for the purpose of smooth running. Well, of the association, and that is precisely what has been contemplated by the order of the Honorable Division Bench. Currently, as it stands on the discussion held by the Secretary of the Competitor in the meeting, the Competitor earlier said all owners are eligible. If that is so, there should be a total number of 150. Now, my lord, if they felt that the special officer wrongly recorded their statement, it was not referred for advice, and this should have been a decision after hearing everybody.
But the competent authority gave this advice prior to the order of Justice Bhattacharya.
My lord, prior to the
order of Justice Bhattacharya. At that juncture, it was in September 2023. Competent authority impugned advice, so-called.
So, yes, advice.
At that point of time, it was observed by the competent authority that every owner is.
That is the advice he gave.
So you say that read in conjunction with the subsequent order of Justice Bhattacharya.
Yes, I will place one more paragraph, but I am not so in a subsequent order. I am only on the maintainability. I am not justifying the competent authority's advice or not.
All right.
I am, because that according to me.
So this consultation did not call for more. I mean, no adjudication was contemplated.
Well, if at all, the special officer went beyond his.
The consultation is not an adjudication or a decision which is amenable to 226.
The judicial review. And also, when the civil, this is a power conferred by the civil court to advise.
Yes.
This is not a power which the Act gives. Let's take it. This is when consultation power has been given to advise to the special officer. So if he has given the right advice or wrong advice to the special officer.
The division bench did not confer any power, could not confer any power, only observed that it is to be decided, is in season and to be decided. It never conferred jurisdiction also. In season does not mean it has jurisdiction. Cannot be.
But that, in
which
fact,
Mr. Rai will also argue.
In fact, the first order does not say he was in season of the matter. The first order,
anyway, take it in conjunction.
Well, when the first order, when it was passed, then there was, that season was not there. Even then, the consultation remained.
Really?
Second order, season of the matter did not alter the first part. So,
really?
Yes, his only advice was only to advise. Consult, basically not even advise, really. The special officer has to ask to consult,
really?
And he has to communicate his decision somehow. It has to be, whether you call it advice or his communication
or his order.
That's why this is not maintainable.
Yes. So whether you call it your judgment, it does not change the character of the consultation. And Lordship, so far as the judgment of Justice Bhattacharya, well, uh, since Mr. Shah, I would not have brought this also on record honestly, because that is, I am on the what advice he has given is not really, in my humble submission, justiciable in a writ court. Or she gives me just 2 minutes, or she kindly comes to the judgment of Justice Bhattacharya, paragraph 35.
Yes. 35 was placed actually.
36 was placed, 36?
35. 36 was not placed.
Well, may I then place 36? Well?
Yes.
In view of the aforesaid discussion, this court is not inclined to accept the argument of Mr. Chaudhary that the percentage of undivided interest of each apartment owner in the common area, as indicated in the original plan, could not have been altered in the revised sanction plan. As such, argument is based on the prohibition against alteration of the particulars in. As such, argument is based on the prohibition against alteration of the particulars in form made, filed, and declaration. So I'm on that sentence that it cannot be changed, has to. But again, I am saying, judgment is consultation and judgment. Well, so it's very, very, very in the Supreme Court judges matter, where the decision, where the Supreme Court, whether the collegium should be.
Yes, that consultation.
So consultation, that it is obligation to consult. But the contents of the consultation, though it may be meditated, it may be formalized, will never be judicially reviewable. What is the advice given by the Chief Justice or President or whatever? So long as the consultation has happened, it is compliance. Here will be with the division bench order.
Right.
There it was with the constitutional provision. And I'll give the reference. I'll hand up the judgment just now, my lord. It is 2009 8 SCC 273, paragraph 44. Paragraph 44. So, in fact, what I would have said is special officer should not have disclosed what advice he got from the part. No one should have known. He has maybe gone beyond, because what he consults and what he gets advice, that was his. Ultimately, it will be. He has to answer the code. That's all.
I'll come back in 10 minutes and hear the competent authority, and then I'll come back to Mr. Chan. Thank you.
The
Yes,
judgment which Mr. Mitra had referred, my lord, we have got the copies regarding consultation.
Yes, yes.
May I just hand up a copy and
Right.
formally place, my lord, the paragraph,
Thank you.
paragraph 44. Paragraph 44, my lord.
Need not place the judgment.
No, no, I will only just paragraph 44, my lord. That's the
44.
44. That's the
Yes,
relevant
yes.
paragraph. Once there is consultation, the content of consultation is beyond the scope of judicial review. Only that in respect of.
Good. What about the competent authority?
I was here.
Lordship, Learned GP is engaged in courtroom number 16.
Either you start his arguments. You are not prepared. You are on the panel also.
No, no, no.
Mr. Chaudhary, let me hear your reply. We'll close the matter now. Yes.
That first thing, my lord, I join issue that, my lord, that the submission has been made as if the competent authority is a mere consulting body without having any power regarding adjudication or determination. Let's put it this way. Now, Lordship made a query that who is an owner vis-a-vis the Apartment Ownership Act. Let kindly come to section 10.
My actual query was who are entitled to vote.
Well, I'll come to that. I'll place the same definition. One thing has not been. Well, Apartment Ownership Act proceeds on the premise. First, a building has been identified. Then an apartment in the building is identified. Then comes apartment owners and then comes the others. Now kindly see section 10. The declaration referred to in section 2, and when I kindly go back to section 2 once. Act shall apply to every property having residential units or both residential and commercial unit, and the sole owner or all the owners or majority of owners of every such property shall submit the same within the period. So first is property, and property has been defined in 3K. Kindly see 3K.
Land and building.
It is land and building, 3K. Property comprised of land and building and common areas, facilities. I am not on that. And then, my lord, it comes to building is defined in 3C. Building means a building containing 2 or more apartments.
Yes.
So property, then building, then comes apartment, then comes apartment owners. Apartments definition 3A means part of a property having a direct exit to road so and so. And then, my lordship will see association of apartment owners means in association competent to contract in its own name and formed in accordance with the provisions made in the bylaws. Now, my lord, come back to section 10 once, my lord.
Yes. 10.
Where does in this act, my lord, the word owner appears? And this is the section. Shall contain the following particulars: description of property, then name of owner, then B, nature of interest of the owner or owners in the property existing so and so, description of each apartment containing its location, number of rooms, description of common area, limited common, and subsection 2. The declaration referred to in subsection 1 may be amended under such circumstances and in such manner as may be prescribed. Now, this amendment was attempted to be sought for by the promoters after, my lord, the flat owners had come in. Now, my lord, this was not told to your lord. The division bench order, my lord, it was a longish order. I did not. The crux of the issue, why the competent authority? Because the competent authority has already held that you cannot amend the Form A. When they wanted to introduce the tower after erecting it, they applied to the competent authority. Competent authority said, no, Form A cannot be amended without obtaining the consent of all the owners. And my lord, the amendment was rejected. That is 10.2 application made rejected. Kindly see the order, page 85.
10A capital. Amendment of it.
Page 85. This is why competent authority is there. He is not a mere consultant that whatever he says, it is not subject to judy. That is why the division bench had sent it to competent authority. Page 85, my lord, order dated 11th April 2018. This Form A was submitted. Kindly come to page 88. I'll only show the relevant portion. Last three paras. This authority has considered respective submission of the parties, examined the materials on record. At the outset, this authority would like to emphasize it is performing the limited function of considering whether Form B submitted by the promoter should be accepted or not. Under the said Act, Form A may be submitted by the sole owner of the property. In the year 2012, the promoter submitted Form A as sole owner, it was accepted. Now the promoter wants to amend Form A by submitting Form B. But presently, promoter is not the sole owner of the property. This is the finding of the competent authority. There are large number of flat owners in the said property by now. In view of this, Form B in its present form is not accepted. Present owners of the said property jointly may submit Form B afresh by seeking amendment of Form A submitted earlier.
So the Justice Bhattacharya held that they are.
Well, I'll come to Justice Bhattacharya.
They are owners. Cannot associate that.
It has not held that. I'll come to Justice Bhattacharya's order. Mr. Mitro did not argue. His entire argument before Justice Bhattacharya was, don't look into Apartment Ownership Act. We are only concerned with NKD Act. Whether the promoter could have individually, even after other owners have come in, could have asked for a sanction of a plan. I'll place that one.
What is the scope of adjudication by the competent authority?
I'll come to this.
Of this question also.
I'll come to this. Now, my lord, Form B, Lordship has seen. So, my lord, now, kindly come back to section 10. So, as of now, the Form A doesn't show the building in existence. And this order, my lord, kindly makes a note. It was appealed.
That is on the virtually on the merits of what adjudication you are seeking from the competent authority.
No.
Who means Mr. Chaudhary that the competent authority has the power to decide this?
My lord, who will determine whether, my lord, the building is within Form A or not?
Competent authority jurisdiction is only 10A, 10B.
Kindly see 10A. Whether it is, that is all it has to decide. Whether it is a property or a building within section 10. That's all.
No, here we are on the question of whether these applicants can come in as electors.
I am not on the applicants at all. I am not on this. I said
the limited purpose of adjudication regarding which the division bench held that the competent authority is in season of
yes, competent authority is season after having rejected Form B. Competent authority will consider whether, my lord, this is a building within the meaning of Apartment Ownership Act and whether they are owners. My lord, the expression owner, this entire election is being done under the aegis of this act. It is, my lord, the association and everything. It's an election of association, not of anything else. Now, if the association of what? Association of members of apartment in the building. Yes. Building is what? Building is section 10. And section 2 is saying this act applies to all the buildings and contents of the which has been declared.
Yes, you say since Tower 8 was not there in that Form A, therefore it does not come within the connotation of that also.
Yes. That is
they cannot come in. That is your contention.
Lord, I am not whether they come. All I am saying is let the competent authority take a stand. That's all. The limited scope, my lord, that is why I did not.
Competent authority has taken a stand.
No.
It has stated that all the owners.
Without going into the issue, my lord, competent authority, without going into the issue, whether, my lord, that is there or not. My lord, this issue was raised before the special officer subsequently. Special officer referred it there.
You are saying, without saying it is Mr. Chaudhary, that it has to be adjudicated then by the competent authority.
My lord, he has to take a decision. My lord, otherwise, no, he has to take a decision. He has to take a decision whether they are owners within the meaning of Apartment Ownership Act. That's all. Within the meaning of the act.
Justice Bhattacharya has not done that.
No. Lord, Justice Bhattacharya's scope, I'll place that order, my lord. I am showing the sections. Lord, kindly note my submissions. The first is building within the meaning of section 10. Then comes apartment.
Yes.
And, my lord, competent authority is the authority to decide whether, my lord, there can be an amendment or not to Form A. And Form A is, my lord, to be read with, my lord, section 2. Once it is under Form A, my lord, the act has application. The act does not have application to any building if it is not in Form A.
Right.
Section 2 is clear. Act shall apply to every property. First, my lord, whether this building will form as a property, residential units within this. As declared in section 10. Kindly see. Registering a declaration setting out particulars in section 10.
What is the last position on that amendment of the Form A?
Milord, appellate authority, they challenged the order before the appellate authority failed.
Page 90.
Page 90 is
So
the
there
order
is-
of the appellate
There is no scope of amendment to that as of today.
No, the only scope of amending the Form A is if all the owners consent.
Yes, that is there. That is-
Otherwise, there is no scope.
As on date, appellate authority stands.
And as on date, my lord, the position as we speak today is that, my lord, the building is non-existent so far as Form A is concerned.
Yes.
If the building is non-existent, the apartment and, my lord, any alleged owner thereof do not fall within the meaning of Apartment Ownership Act. This is, my lord, these submissions I am making only to respond to Mr. Mitra and Mr. Saha's submission. My lord, our scope in the writ is very limited. That when, and my lord, these issues, my lord, kindly see the order of the division bench. These have all been narrated that why this issue has arisen. All these sections have been referred to in the order of the appellate court. And thereafter, my lord, the competent authority, the special officer was directed to consult the competent authority.
Division bench cannot confer jurisdiction. Mr. Chaudhary, show me the jurisdiction of the competent.
I am not saying division bench has conferred.
Show me the jurisdiction of the. You are asking for an adjudication.
Yes, my lord, kindly see.
Authority. Show
Yes.
me the jurisdiction.
Jurisdiction of competent authority.
Yes.
Kindly take the
To decide this.
Yes.
Here, the declaration has already been submitted.
Yes.
There is no dispute on that. So 10A, how can 10A come in? 10A says a declaration, section 10A.
Yes.
A declaration of order and instrument to be submitted before competent authority and to be dealt with by him.
Yes.
It has been dealt with by him.
Yes.
So where is the question of reopening that issue? How can I decide now something else?
No, it's not a question of reopening. He has dealt with the issue. He has held that the Form A as it stands will remain unaltered.
Mr. Chaudhary, first formulate the issue which is to be decided by competent authority according.
My lord, first thing is, my lord,
yes,
competent authority is the only person who can determine
what?
Who can determine whether the property or whether the property is falling within the ambit of Form A or not.
Tower 8.
Property, I am saying property.
No, the dispute is only regarding Tower 8.
Tower 8, yes. Whether it is a property within the meaning of section 10, read with Form A. And second, competent authority as per order of division bench is to prepare the electoral roll with the special officer.
That he is doing.
Why the competent authority? Had it been, let us assume, I take the argument, competent authority has nothing to do with this. If in the background of these issues, if I go back to the division bench order, the Apartment Ownership Act, all these issues have, pages are there. Lordship will go into that. It has been recorded.
What was the issue before the division bench in the suit?
This was one of the issues.
So division bench did not decide it. Left it on the competent authority.
No, division bench said that whether I did not hear the Tower 8 people. Now, my lord, kindly see the dichotomy in the fallacy in the argument. On one breath, it is being said that the division bench has not decided the issue. On the other breath, it's saying that judicial review does not lie. If at all, they have to raise it before the division bench.
Mr. Chaudhary, if you wanted an adjudication on this, you had to go before the division bench or the civil court.
No.
Why come up here? I mean, you are going before the competent authority. You are going before the competent authority, not before the civil court.
Today, my lord,
was the competent authority to decide this?
My lord, forget this matter. My lord, today, if in any project, my lord, a tower comes up or a construction comes up, which is in violation of Form A, which is the authority I go to? I ask this question to myself.
For what? For what? What is the cause of action? Tell me that.
To say that
cause of action.
To say that it is in violation of Form A. My lord, why this Form A? My lord, I had explained it in the other matter also.
I don't find any jurisdiction of the competent authority once the Form A is accepted and it is dealt with as per 10A. I don't find anything in 10A or
that is exactly
to take up a post facto adjudication, subsequent adjudication if a dispute arises again after Form A is accepted. I don't find anything in
the dispute has not arisen again. My contention has been upheld. Form A as it stands has been upheld. So, my lord, as it stands today in Form A, there is no existence of tower 16 or tower number 8. Now, my lord,
You are asking this court now to say you are challenging
all I am saying,
authority. You are saying competent authority has to decide the issue.
yes,
What issue?
decide the issue whether the members of Tower 8, my lord, are owners within the meaning of the act. That's all. Are owners within the meaning of this act. Once, my lord, if he holds that they are owners and can participate in the election process. Vis-a-vis, my lord, given the parameters of section 10 and my lord, the other sections. Yes. Because, and my lord, the background is the order of this. Once otherwise, my lord, it's like this. An adjudicating authority holds that I am not allowing any alteration. But on the other hand says that in the altered premises, I am recognizing the rights of the occupants, my lord. I don't see how these two can be reconciled.
Right.
Now, my lord, kindly take Justice Bhattacharya.
Yes. Mr. Choudhury, please place the relevant portions. I will
Only.
one or two other matters also.
Yes, sir, 2 paragraphs.
Motion bench, that's a difficulty. Yes. Argue, make sure argue.
The subject matter before Justice Bhattacharya was the sanction plan was challenged, by which NKDA granted permission to erect it. The argument of Mr. Mitro before Justice Bhattacharya, Justice Hiranmaya Bhattacharya, was that NKDA Act is not concerned with the provisions of Apartment Ownership Act.
Show me that paragraph.
Yes. Because, my lord, this case was cited.
Right.
My lord, I just show one paragraph and Justice Bhattacharya has, because of the judgment, and may I show the other para? My junior will take that up. Let kindly first comes to, yes, para 9. That is why, my lord, he was hesitant in saying Mr. Shah relied on this judgment. He was hesitant in relying in this. Mr. Mitro submitted, NKDA has no authority under the 2007 Act to administer law relating to 1972 Act. This was the argument. And now this judgment is being shown that Justice Bhattacharya has already held. Therefore, according to him, NKDA, while granting sanction, was only obliged to ensure compliance with the provisions of 2007 Act and 9 rules. And he relies on Bijoy Jain, and relying on Bijoy Jain's ratio, Justice Bhattacharya has held. But I have reasons to differ, my lord. My clients have preferred an appeal. Section 75P has been A has been overlooked. NKDA Act says that you cannot sanction a plan if it is in contravention of any other law. This section was cited, but somehow, my lord, the bench has missed it. But we are not concerned. The entire, and my lord, this will be clear from the finding of the learned court. Now, lordship will see para 35. Para 35, my lord, this is what has been relied to.
Yes.
Learned senior advocate for the petitioner in course of his argument could not point out any provision in 2007 Act restricting 2007 Act is, my lord, NKDA Act, not this Act.
Right.
Restricting power of promoter to make any alteration in plan specification particular so and so. In absence thereof, this court is of the considered view, provisions contained in 72 Act prohibiting alteration of each apartment in the owner cannot prevail upon the provisions of 2007.
So this was not an adjudication under the Act.
Now kindly see para 39. It is well settled that Municipal Development Authority has to act within the four corners of the statute which creates it, and also that it cannot enforce provisions of any other law. That is Apartment Ownership Act. Then Bijoy Raj Jain, a coordinate bench observed, obtained. My lord, I had distinguished the Bijoy Raj Jain by showing, my lord, section 75A that has not been reflected, but be that as it may. Apartment Ownership Act, Justice Hiranmaya Bhattacharya has not touched at all. It is absolutely incorrect and perverse to say that the learned judge has held under the Apartment Ownership Act.
So as of date, you say the crux of your argument is as of date, there has been no adjudication on that.
So
tower
there is, my lord, kindly see, I summarize. There is I won't use the word adjudication. No decision also of the competent authority that these are the owners within the meaning of the act. Or that this is a building, Tower 8 is a building within the meaning of the act under section 10. After having passed the order at page 88. And my lord, other than the fact, my lord, violation of natural justice, they don't even call, competent authority doesn't even call for any hearing, either us or them. And they rely upon that August minutes of the meeting where they say, competent authority is under the impression these are all valid towers.
No reason.
And my lord, lastly, my lord, lordship has already observed, it is unreasoned.
Where are the adjudications of the competent authority? You say that the competent authority has adjudicated already, which was an appeal was preferred against that.
But at page 85, page 85,
yes.
At page 88, if lordship sees,
Yes, right.
Well, at page 86, I'll just show the submission. Para 6. According to the promoter, the plan was applied for sanction to NKDA. After obtaining sanction, promoter recommends construction on the basis of the plan. Since in Form A submitted in 2012 did not mention the entire construction, there were certain errors or mistake in Form A. The promoter on 10th January 2017 submitted an application for amendment of Form A through submitting Form B of the rules. This was rejected. Appeal preferred page 90, rejected. Appeal said that no, all that if you want to amend Form A, you do it as per the statute. So, my lord, if these two orders remain as it is, how can any building or occupants of a building at all assert any right under the Apartment Ownership Act? And all this is, of course, my lord, this will be a submission before the competent authority. But let him first give a hearing, we will make the submission and he will take a decision.
You missed your bus, Mr. Rai.
But I was just outside.
What do you want to add to this?
And may I just 2 minutes, my lord. My lord, first, your lordship has seen page 89, which my learned friend just now showed. My lord, kindly sees page 90. Even the appellate authority relies on both the parties' submissions. There are 1511 flat owners. Now, my lord, the scope of this act is not to adjudicate who are owners. Or
how could you say that all for the purpose of electoral roles?
I've got no role to play in that. I cannot have a role to play in the matter that the property.
So the division is directed you to be consulted.
Consulted. Consulted for what, my lord? May I just very quickly, my lord?
Yes.
Kindly takes. But before that, my lord will kindly see. First, your lordship has seen that it went up. My lord, there was a order passed by the division bench saying that these persons will not go into election, Supreme Court, then vacating.
Please once come to page 180, then I'll hear you definitely.
180, my lord?
180.
Yes,
please.
my lord, definitely.
The last sentence.
My lord.
The very last sentence, so please place that, Mr. Rai, once.
Orders related upon Mr. Chaudhary that were passed in the pending writ application would not show that the present petitioners were debarred from exercising their rights under the respective deed of purchase, nor the issue as to whether they would be considered as owners under the Apartment Ownership Act.
This is very vital.
Yes,
that
sir.
was not decided. The next sentence.
It appears that the competent authority is in session over the matter.
In this context, you are directed to consult.
Yeah, may I just
Line
point?
for that, whether they would consider as owners under Apartment Ownership
Malad, let
Act.
us not take everything in piecemeal. We cannot do that.
No.
Malad, that proceeding was before me, and I was in session under the Apartment Ownership Act. Why? Because a declaration was to be given so that it could come under the aegis of the Apartment Ownership Act. That is what I'm supposed to look into. I'm not supposed.
How could you say he raises a question, page 276, the impugned order?
Yes, sir.
Every flat owner is a member of the association as per the provisions.
Yes, my lord.
So the election to be conducted with 1511 flat owners.
That's in the bylaws.
Which
You see the bylaws, my lord. My lord, just give me a moment, my lord. I'm sorry, my lord.
Yes.
In the original bylaws, my lord, this on the basis of this bylaws are created. My lord, three. My lord, I don't know to which. This is the West
You
Bengal
say in the bylaws, what is there in the bylaws? Just tell
But
me
I
that.
just read it. West Bengal Apartment Ownership Bylaw 74.
Yes.
There shall be in respect of each property and association, and each apartment owner of such property shall be member of such association.
Bylaw 22. Bylaw 22.
Yes.
This is the
318.
But I'll just point out, they're saying that the bylaws have changed. But no, it is still there, Malad.
318 is there.
Yes,
Yes,
it's
it is there.
Yes.
So, Malad, that is the scope. Now, Malad kindly sees, your Lordship was seeing, Malad, section 10, 10A. Malad, there is a very important thing there, Malad, because this is a special statute. I have very limited jurisdiction unless it is provided. 10A, Malad, also provides the last sentence of 10A1, if your Lordship sees, the remaining owner shall be allowed to submit declaration subsequently at the individual or collective. Why I'm saying this, Malad? Has your Lordship got that, Malad?
Yes.
So, Malad, the scope is 10A or the declaration has to be submitted by the sole owner, some of the majority owners. That is the scope. So, Malad, when the declaration is given to me, I do not need to consider each and every person's ownership rights. My learned friend is saying, I have to see whether this tower is within that property and acceptable as a tower. Malad, kindly see section 10. It says description of the property. Now, within that property, Malad, if there are apartments, I only have to see whether there are apartments or not.
Each of the towers can also be treated to be apartments.
But if there is a yes, definitely, Malad. I will only have to see that there are.
Or it is not there in the declaration and the Form A. So how can you treat those members as
Malad,
part of the electorate?
It was description of the property is required there.
Let us consider the worst. Today, Form A does not contain this tower 8.
Let us also consider there is no tower 8 today. Let us just consider this one, hypothetical.
Very well.
Because it is pending before NKTA.
There is no tower 8, there is no difficulty. Then all the members come.
There is a provision.
Tower 8 and Feng Shui is correct apparently.
That I can understand.
Chaudhary says Feng Shui, due to Feng Shui, Tower 8 was not there.
Most important.
See, it is litigated.
Most important thing, Malad, what Mr. Chaudhary said was very important. He said whether this property is can go under the Apartment Ownership Act.
8, Tower 8.
Building. That is what I'm saying. A tower within the property, Malad, whether it is proper or not, Malad, till the tower is there, Malad, it forms a part of an apartment, because I cannot hold that whether that is.
Form A does not contain anything regarding that tower. So that tower, vis-a-vis the Form A and the declaration, he is saying it's a stranger. I mean, that Tower 8 is non-existent.
I have to consider the entire property as a whole. If it conforms to sole majority owners, I am required to only form the association. But let us say there's a 9th tower coming in. Can this declaration again come in? I'm asking myself.
Would that improve the situation for you? 8th or 9th or 10th?
No, that's the point, Malad.
Remain the same.
Yes, it will remain the same. So, Malad, where is my authority to deal with the title of a property? Is that what he's asking for? And Malad sees the last order of justice sent the division bench. But before that, Malad, can you see 248 once? Just once, very quickly. Let's finish it. 248. This was the first order. Special officer in consultation with the competent authority shall prepare an electoral roll. So who's going to prepare? If I ask myself, the special officer. And decide on the mode of voting.
This has to be read along with 180, 181, he's saying.
Malad, let us see what is happening, Malad. The flat owners of the newly constructed tower, however, should not be included in the electoral list in view of the pending litigation. Now, Malad, let us just go back to 180, Malad. Malad, kindly sees page 180. Just yes, Malad. Malad, this your Lordship kindly sees, Malad, just from the top at 180. When we passed the order, the applicants were not heard. So this was the vacating application of Mr. Shah's
clients, my lord. Now, my lord, kindly sees whether the applicants can be just in the middle. Applicants will be considered as owners when the meaning of section 3(1) of the apartment regime was not considered when it decided the said application. The point was never urged nor argued. Applicants discussed title is established, they have purchased the flats. Then it is not necessary for us in this proceeding to decide if by reason of such deed they will be entitled to participate in the election. Because I also do not have that. The parties have already disclosed proceedings with the competent with regard to objections concerning Form A and Form B. This is not the subject of a suit or a matter that was urged before us when we restrain the applicant purchaser of flat in tower number 8. Now see, orders relied upon which were passed in pending, it would not show that the present petitioners were debarred from exercising their rights under the respective deed of purchase, nor the issue as to whether they would be considered as owners under the Apartment Ownership Act of 72 were gone into and decided.
But the issues involved in the suit were the management of the property by the association.
Yes, that has to be an independent dispute. I cannot go into that, my lord. That because the civil jurisdiction.
But the court says if difficulties division bench says at page 180 it is not necessary for us in the proceeding to decide.
Well, at that stage, my lord, application definitely.
That is not.
Kindly see that at that stage Form A was pending.
No. That is not the finding.
But
Finding it is not necessary for us in this proceeding to decide if by reason of such deed they would be entitled to participate in the election is all important for formation of the association.
No,
that is not decided by the division.
But association already formed. This is not under chapter 2, chapter 3. Association formed and Form A filed, chapter 2, section 3 done in 2012.
Yes.
This is re-election, not a first election.
After,
not the first election.
No.
It is further out of my jurisdiction. Form A, my lord, is the first precursor.
Very well.
So therefore, my lord, I do not have the jurisdiction to decide on title. And my lord, last, my lord, kindly sees, I will only have to take a holistic approach. Even if I'm supposed to look at owner, because I'll be bound by this order, my lord, this act. Owner also, it's an inclusive definition. And any person deemed to be owning such property. And my lord, I was not called upon to give any order. For that matter, my lord, I was supposed not required to give any reasons, my lord. But as it is, there is a reason. And I'm relying on that appellate order. The appellate order also says that 1511 owners. And I've shown, my lord, the bylaws, every member has a right. If they have any dispute, my lord, we all end up in civil courts, my lord. And that is what is done. And I do not think the competent has the jurisdiction to decide on this ownership point, my lord. But what would happen if this is decided by the competent authority? Then, my lord, all other proceedings and then we passed by this order, my lord. There are so many writ courts, there's a civil court looking into it, my lord.
Conclude arguments.
Grateful.
The appellate authority's order has not been placed.
No, I just.
Yeah,
Both placed. Both of them placed.
Yes.
Page 90, both of them
One
placed.
by one, I told him.
Mr. Mitra was not there. I placed
85, page 85, 88,
Court,
90, all placed.
Appellate court.
Hearing is concluded. Judgment is reserved in the matter on Indita. Next.
I'm very sorry, my lord. I was just rushing, my lord. I couldn't make it, my lord. And I've understood I was 7 seconds late, my lord.
Judgment reserved on this also.
My lord. My lord passes some direction where I can. Very grateful, your lordship.
Grateful.
Yes.
Item 7.
7.
Put the petitioner, my lord.
Yes, please.
Under the petitioner, my lords, the executed Nirupan Patra in the year
Please take the microphone a bit closer to you.
Nirupan Patra was executed in the year.
I can't hear you.
Nirupan Patra was executed in the year 1990.
Place for registration.
Place for registration, my lord. That stamp paper was forged, my lords.
You want to pay the amount?
I want to pay the equivalent amount.
Usual order?
No, my lord.
What no, my lord?
My lord, he said in the petition, my lord, page, my lord, para 3, Nirupam Khudiram Bak is the executor of the deed, my lord. But they did not execute this deed, my lord.
Registering authorities can decide that?
No, my lord. This deed was executed by one Kajol Lani Bak, not Khudiram Bak. He suppressed the material facts, my lord.
Have you got a copy of the deed?
No, my lord.
No, my lord, the original deed is lying with the.
He has not annexed in the IGR, my lord, also.
IG is annexed, my lord. Page
No, my lord, this is not the IGR. It is a
searching report, searching slip. But I got from the
Produce the deed of settlement. Bring it on Monday.
My lord, I got instruction, my lord, 173, my lord, 2096. My lord, deed number, my lord,
Learned
2096.
counsel for the petitioner argues that the petitioner presented a Nirupan Patra within bracket settlement deed bracket closed for registration push up. However, the registering authorities are refusing to register the same on the ground that the stamp affixed to the deed was forged. Push up, the petitioner is agreeable, comma, it is submitted, comma, to put in equivalent amount of money as the stamp and have the deed registered. Push up, next parallel, and counsel for the registering authorities submits that in paragraph number 3, it has been stated that one Khudiram Bagh executed the deed. Push up, however, comma, it transpires from the concerned deed that someone else executed the same.
One
Push-
Kajal Rani Bagh, my lord.
Accordingly, it is submitted that there is discrepancy in the deed itself with the averments made in the writ petition. Push up, to resolve the issue prima facie, comma, the learned advocate for the petitioner is directed to produce a copy of the concerned settlement deed in court on December 4, 2023, when the matter shall be placed at the top of the list.
Grateful, lord.
Next.
Item 8.
May it please your lordship.
Yes, please.
On this writ petition, my lord, I'm seeking an innocuous prayer for disposal of my reference application under section 18 of the MSME Act, my lord. Now, section 18, my lord, this reference application was filed on 5th July 2022. That your
It
lordship.
has not crossed the conciliation stage.
No, my lord, hearing
Filed.
on 5th July 2022, not even a single hearing given, my lord.
The innocuous prayer of the writ petitioner is that the MSME Council is sitting tight over an application under section 18 of the MSME Act filed by the petitioners on July
5th July 2022.
on July 5, 2022. Push up, next para. Please file your affidavit of service.
Yes, my lord, affidavit of service.
You are appearing?
My lord, I am for the MSME.
Council.
Yeah.
So I'll direct you to pass orders on this application. The affidavit of service filed today be kept on record. Full stop. Heard learned counsel. Full stop. WPA 26701 of 2022 is disposed of by directing the MSME Council, that is the respondent number one, to pass to take up the application of the petitioners under section 18 of the MSME Act for passing orders immediately. Full stop. Next para. It is expected that that the MSME Council shall so take up the application at the earliest, comma, positively within a fortnight from date.
Grateful, lordship.
Pass orders, because I've kept it vague deliberately. You have to decide whether it's maintainable before you, whether conciliation is possible, other things. Pass necessary orders. Just for passing orders, within 2 weeks, pass the first order.
Grateful, lordship. Grateful.
Item 9.
I beg to appeal for the respondent, my lord. At the outset, my lord, there is an indulgence I'll be seeking.
Yes.
My lord, there was a direction for filing an exception. Now, my lord, the central warehouse, it is going through an internal audit, my lord. I could not get the assistance of the officers. I have affirmed an exception, but my lord, it is not satisfactory to me, my lord. To assist your lordship, I would require certain.
I strongly oppose to this. Their exception has been served on me.
It has been served. I have affirmed.
There is nothing
Just
more.
in
I am sorry,
compliance of your lordship's order.
This is a deliberate attempt. This is a deliberate attempt by them.
You have not got a copy of that?
I can
withhold
show
my
your
money.
lordship, there is an order, there is an internal audit going till
strongly
today.
Mr.
1
Chaudhary,
week, my lord.
How soon can you do it?
1 week.
Madam.
There are certain documents, my lord, where
Everything is
FCI
admitted.
relies upon.
Learned counsel for the CWC submits that
Very unfortunate.
CWC within bracket respond numbers 2 to 4 bracket close submits that certain alterations are required to be made in the copy of the it was what was it to be an objection?
It was an exception, my lord.
Uh,
There was a
to the-
report which was
to the
filed by-
proposed exception to the report as per previous direction, comma, a copy of which has already been filed on the petitioner. Full stop. Learned counsel for the petitioner strongly opposes such prayer and submits that nothing else is to be disclosed and the matter be taken up. Full-stop. Learned counsel for the FCI submits that no copy of the said exception has been handed over to him. Full-stop. As a last chance to the respondent numbers 2 to 4, comma, the matter is adjourned till December 8, 2023, when it will be placed fairly at the top of the list. Full stop. It is made clear that the respondent numbers 2 to 4 shall positively file their their exception on the said date, with advance copies being circulated to the petitioner as well as the FCI. But this is the last chance, Mr. Chaudhary. I'm very clear on that. Mr. Chakravarti, just show me this order on the executive.
And apart from the disputed amount, there are at least 1 crore 20 lakhs which they have admitted, which not they could pay me easily today also. There's no dispute on that, but it is just not being lingered. And my money, it is not their money, it is my money which has come from FCI through them. They had to disburse.
If they're not ready with the exception, I'll direct them to pay after adjusting Mr. Chaudhary's fees. Yes. Yes.
Item 10.
10.
Well, this is my application, Malad.
Yes, Mr. Rai.
Sorry.
Yes. Oh, Mr. Rai, both sides. Yes.
Malad, this is an application.
Mr. DNA, please take your seat. Yes.
Malad, scope of entry amount are very limited at this moment. I'll point out why, Malad. When I made the application, Malad, I had a clear claim of 21 crores against my learned friend's client. That's the railway authority, Malad. I had built, Malad, a siding terminal.
Siding?
Siding, Malad. Siding terminal.
Terminal.
Where, Malad, railways go to the sidings, and for that purpose, Malad, these are deposited. Goods are deposited. That is used, Malad, that is generally supposed to be made by the railway authority.
You built the terminal.
Terminal, yes, Malad. That terminal is generally required to be built, Malad. There are 3 policies. One of 2016, amendment of 2021, and then 2022. Malad, 2016 policy said that I and the railway could share and build this terminal. Now, Malad, after that, Malad, when I started building, the other policies started coming. In 2022, the policy is that I will have to build it and they will reimburse. And how will this reimbursement take place? If I cross 1 million ton of inward and outward goods traveling from that terminal, I'll get 10% subsidy. This is the policy. I'm just giving a lordship back scheme. This is the scheme, Malad. I had applied to them. Malad, initially I got all documents. Malad, it was unheard of. That's why, Malad, when I filed the request, I did not give the documents. I said, give me my money, I came before your lordship. Now what they do, Malad, that's why I had to file a supplementary affidavit given to my learned friend also, Malad. They say you have not got the permissions required from us. And the permissions are all here. So, Malad, I was only seeking, Malad, because today I was also seeking that let the money be given to me. But obviously now, since they've taken this point, Malad, I really cannot stand in the way. But Malad will kindly see, Malad. Oh, Malad.
What is the meaning of that expression?
Malad, may I be permitted leave, Malad? Permits to ban
Yes, Mr. Rai, should I direct affidavit?
This matter possibly cannot be dealt with without not calling for affidavit.
Yes, exactly.
Because we are definitely opposing the application. They are seeking reimbursement to the extent of 10%. But the policy which was existent at the time of construction, that does not mention anything which they are seeking.
2022 policy does not have
the policy does not mention about the reimbursement. That is our whole stand.
They say it has been amended in 2022.
So even then, Lord, it does not mention. That is our specific instruction in writing. That is our specific instruction.
Policies have been annexed. You have got.
Yes, Lord, it's annexed.
If the lordship kindly grants leave to
yes, Mr. Banerjee, I'll direct affidavits because factual question. I'll grant you leave to file that supplementary affidavit and composite affidavit will be filed by them.
Because what they, Malad,
basically a money claim.
Malad has already, Malad, I'm sure Mr. Malad has already told my lord, it's a 10% reduction, Malad, which we get in respect of the capital investment which we have made. Because, Malad, these terminals actually become, Malad, public. Previously, Malad, originally policy was, Malad, that it belonged to me. But then they changed the policy, Malad, with the Gati Shakti cargo terminal operators policy coming in, where, Malad, becomes public. And, Malad, I get 10% reimbursement, Malad, from the freight which I've, Malad, get. And that's the policy. I'm sorry, my learned friend says instruction may not be
Very well, I'll record that you have made out a prima facie case, so I'll direct affidavits. How soon can you file, Mr. Rai? Affidavit? Railways?
23 weeks. Malad, I get show Malad, page 216, Malad, the policy itself says, Malad, just kindly Malad, have just one look, Malad. 216. Just only one page, Malad, 216. Yeah. And this was also there in the 2021 policy. Can you look at 216, Malad? 5.2.2. The GCTO, that is Malad Gati Shakti Cargo Terminal Operator Owner, in order to expedite commissioning of his terminal, also for bearing the cost of common user traffic facilities that is to be normally borne by the railways. Subject to the condition, work shall be executed through such, and all this is done. Then yes. An amount equivalent to 10% freight discount only on the total goods traffic handled inward as well as outwards in the GCT shall be reimbursed to the GCTO in lieu of bearing the capital cost for common user tariff facilities. And what is important, this reimbursement of capital cost to CTTO shall be done after due verification from the accounts department. All this is not already done at the concerned division and shall be for a period of 10 years or till the recovery of capital cost, which is earned. So I hope, Malad, they don't say, Malad, that the period.
May I just draw your lordship's kind attention to this, Malad. With reference to what has been said by my learned friend, Malad, the answer is, Malad, the amendment was issued on 14/6/2022. That is after commissioning of the siding, wherein it has been mentioned by para 5.2.2 that the GCTO owner, in order to expedite commissioning of his terminal, may also opt for bearing the cost of common user traffic facilities that is to be normally borne by railways. Here it is to be noted that it has been told that the word to expedite the early commissioning of the siding has been used. It has not been mentioned that the amendment will be applicable for already commissioned siding. So the amendment came into force after the thing was commissioned.
I'm sorry, how illogical. Malad, if I bear the capital cost, you make it a public user, and then you say you will not reimburse.
The question which has been raised by the petitioner is whether the petitioners, who constructed a siding terminal for the respondent railways are entitled to an amount equivalent to 10% freight discount only on the total goods traffic handled in terms of clause 5.2.3 of the concerned amendment number 1 to the master circular on the Gati Shakti multimodal cargo terminal policy dated June 14, 2022. Next para. Whereas learned senior counsel for the petitioner contends that the petitioners are entitled to the said amount, learned counsel appearing for the railway authorities places reliance on certain documents to argue that the said clause is applicable only to terminals which were not commissioned at that point of time, which had not yet been commissioned at the rail.
It was already commissioned. So
theirs were commissioned already.
No, the amendment came into force after the construction work, after it was commissioned. Therefore, the pre-amendment policy would apply to them. Pre-amendment policy would apply.
Comment কি জায়গাটা কি বললাম যেখানটা ছাড়লাম?
Agreement Malad is January 2022.
Were being commissioned at the time of the amendment, whereas the terminal constructed by the petitioner had already been commissioned prior to the coming into force of the amendment. Since an arguable question has been raised, the writ petition is required to be heard on its merits. On the prayer of learned senior counsel appearing for the petitioner, the petitioners are granted leave to file a supplementary affidavit, which is filed in court today and kept on record. You have served a copy. A composite affidavit in opposition to the writ petition as well as the supplementary affidavit shall be filed within 3 weeks by the respondents. Reply, if any, shall be filed by January 5, 2024. The matter shall be listed for hearing on January 8, 2024. January 8, 24.
Grateful.
Thank you.
Service.
The same position.
There was some Malad. I'm sure Malad, yes, Malad, some Malad, because that period in the end, my lord, is 10 years.
3 years, 1 week, 3 weeks, 1 week.
Yes,
takes
no,
us there.
my lord, if my lord, the hearing, my lord, when it comes up, my lord, for hearing, my lord, if some precedents, my lord, on.
Not this hearing, no. It will take some time. You are there, Mr. Rai is there on the other side.
আপনার জন্যই বলুন।
And it's around the other side.
Grateful.
Item 11 and 12.
Yes. Yes, Mr. Haldar.
I'm for the petition, Lordship. Item number 11 and 12. Lordship, on the last occasion, there was direction to file file report by the state. Lordship said had not been handed over.
What is this insufficient address? One of the services says insufficient address.
Lordship, they are appearing. And Lordship, I will be praying for another indulgence, Lordship. I will be praying for 1 day accommodation, Lordship, without briefs, Lordship.
Without brief?
Today, I am not without brief. And I have not received the copy of the report also, Lordship.
What about the report, Mr. Chakravarti?
Yes, ma'am, the report is with me, my lord.
Give a copy to him.
I'll give it by 2 days, my lord. My lord, just, my lord, the point of maintainability was open. I may indicate why. Because, my lord, they had applied.
When I take up the matter, argue it. An adjournment is sought by learned counsel for the petitioner. In any event, since no copy of the report proposed to be used by the respondents has been served on the petitioner, let the matter stand adjourned till December 4, 2023, when it will be listed under the same heading. You have given a copy?
Lordship.
A copy of the report is handed over here and now to the learned advocate for the petitioner. You are filing the report also? File the report also. Then.
My lord, I have only 1 copy.
Very good.
My lord, only thing, man, I like to make an affidavit in this matter. I'll tell you why, man, just because I indicate. Because there have been 2 proceedings.
Mr. Chakravarti will consider when I take up the matter.
Grateful.
Item 13.
Lord, I am appearing for the petitioner.
Yes, please.
Lord, petitioner is the major shareholder and corporate guarantor of pro forma respondent number 5. Now, Lord, what happened, my lord? Petitioner being the shareholder, my lord has been aggrieved by various inaction of the bank. Now, my lord, pro forma respondent number 5, my lord, they have sent a representation, Lordship, kindly see annexure P18, page 120, to the Central Vigilance Commissioner, Central Vigilance Commission in the year 19th. But my lord, that my lord, representation is still pending, my lord, for consideration. And in the meantime, my lord, during the pendency of the writ petition, my lord, respondent bank, my lord, has published, my lord, e-auction sale notice that will be held on, my lord, 16th December, my lord. Lord, kindly see, my lord,
it could interfere.
There is already a SARFAESI application pending in Delhi
yes.
by the borrower.
No, my lord,
you add yourself there.
No, my lord,
you have a separate cause.
Yes, but my lord, my grievance is, my lord, Lordship, kindly see annexure P18, page 123, my lord, representation by the pro forma respondent number 5, in which, my lord, I am the major shareholder and, my lord, also corporate guarantor. My lord, filed, my lord, representation to the Central Vigilance Commissioner, but my lord, without, my lord, that is still pending for adjudication.
You are colluding with your own company.
My lord,
same persons involved. Same.
You are the corporate director.
Corporate
You wrote to the Central Vigilance Commission against your company.
No. Corporate guarantor, no, against the bank.
You are the corporate guarantor.
Yes, my lord. Corporate guarantor and major shareholder.
So what? Yes.
Of the my lord, pro forma respondent number 5, who is the my lord, main borrower.
Oh, you wrote against the
bank, my lord.
activities of the
Yes,
bank.
yes, my lord. My lord, I am.
What nexus does it have with
my lord, I am financed by my lord, consortium of bankers, my lord. My lord, led by my lord, Dena Bank. Now, my lord, it has been merged with my lord, Bank of Baroda, my lord.
Okay. When did you file this? There is no date on this?
My lord, 15th. My lord,
123, page 123, there is no date.
Yes, my lord.
You have just annexed it to the report.
Yes, my lord, that is my lord. It has been, my lord, let's kindly see, my lord, page 21.
You are appearing for the bank.
Bank.
Is the CVC represented?
Well, CVC has informed us, our Vigilance Commission, to represent the CVC. But I have not received any written communication from the CVC directly or any authority from CVC directly. There is a mail from CVC informing our Vigilance Commission of the bank to represent them. But I have received.
And then there's a collusion between CVC and you.
I do not. I would not say that.
He has a point.
My lord, the main question or the issue raised here is non-representation, non-consideration of this representation. Even the main prayer made here. My lord can direct consideration of that.
My lord, I have been suffering, my lord, since 2014. My lord, I have been financed by, my lord, consortium of bankers, my lord.
You gave
several-
this
my lord,
representative, what is the date of this representation?
my lord, it was, my lord, complaint was registered, my lord, why no, my lord, lordship can see page 21.
Give me the date.
My lord, the date, my lord, 15th April 2019, and my lord, was registered, my lord, by CBC complaint number 129254
Why
of
did you wait for
2019.
4 years? Why did you wait for
Action
4?
date
Why did you wait for
27/22.
4 years to file this writ petition? Since it is pending since 2019, you took no steps.
Yes, no, thereafter, my lord, COVID has come, my lord, and my lord, thereafter, my lord,
No relief can be granted.
my lord, various, my lord, I visited, my lord, my several times, my lord, their office, my lord, I was assured.
Counsel for the
I was
petitioner
assured.
submits that the petitioner is a
Lordship, kindly
major
direct,
shareholder,
consider my representation and
major shareholder and a corporate guarantor
of pro forma respondent number 5, my lord.
in respect of pro forma respondent 5 company. Who's up next para? It is submitted that although the petitioner wrote to the Central Vigilance Commission, that is respondent number 4, comma, which complaint was registered on April 15, 2019, comma, against irregularities and illegal activities of the respondent bank, comma, no action has been taken thereon by the said respondent number 4. Full stop, next para. It is submitted that in the meantime, the bank has taken action on an alleged debt of the pro forma respondent number 5, and the auction sale is scheduled to be held soon. Full stop, next para.
December.
Learned counsel for the bank submits that that already an application under section 17 of the SABYASACHI Act is pending before the concerned debts recovery tribunal. Puts up the remedy of the petitioner, if any, lies before the said forum. Puts up next para. It is found that even as per the averment of the petitioner, the complaint was allegedly registered on April 15, 2019. Full stop. The petitioner, comma, for some unknown reason, comma, sat tight over the matter for 4 years and has only filed the present writ petition in September 2023. Full stop. Apparently, comma, such promptness of the petitioner was due to the SABYASACHI action taken by the bank. Full stop, next para. Hence, comma, there is no apparent nexus between the said complaint and the SABYASACHI action taken by the bank, comma, against which the relief of the petitioner lies before the concerned debts recovery tribunal in the pending proceeding or in an original action taken by the petitioner. Full stop. Hence, comma, there is no scope of any relief in the present writ petition. Full stop. Insofar as the complaint before the Central Vigilance Commission is concerned, comma, since the petitioner chose to wait for 4 long years in moving the same, comma, the petitioner is not entitled to any equitable remedy under Article 226 of the Constitution of India. Full stop. Accordingly, WPA 22045 of 2020
Well, kindly, well,
is
consider,
dismissed without any orders to cause.
well, kindly consider my representation. Well,
No, your only reason is to stall that proceeding.
Well, property in Delhi, account of Mumbai.
Order in Kolkata.
Order in, well, only he is in Kolkata. Rest all are in Delhi.
But I am the,
I have not gone into
I am the well, major shareholder, and well, also, well, Yorkshire
You have been set up by the company, obviously.
well, Yorkshire sale notice, well, also, well, I am, well, as a, well,
Colonel.
corporate guarantor, well, I am
14.
also party, well.
Yes, 14 who is appearing. Yes, strategy, what is the matter?
My lord, petitioner, my lord, running one, my lord, the husking mill and paying, my lord, my month bill.
Right.
Last bill shown, my lord, 3rd August 2023, I have paid, and my lord, there was no outstanding. Thereafter, my lord, the distribution company inspected my premises and observed that my contractual load is 13.616 kVA, but it is reported that there is excess load of 21.9 kVA. That is why the distribution company directed me to apply for enhancement of load. As per provision, my lord, 3 of the, my lord, 46 of the, my lord, West Bengal 4.3, no, that is, I applied to the authority for enhancement of load, but they have issued a quotation amount of rupees, my lord, 62,000 and odd, 69,000 and odd. But my lord, I have challenged the part, my lord, with regard to, my lord, kindly come to page 18. With regard to, my lord, the load enhancement charge 18,573, that is the statutory, my lord, charges I am I am duty bound to pay. But the other, my lord, charges that, my lord, almost 51,416, that is illegal, because the provision says that, my lord, 46 WBSERC, my lord, stipulate that if I applied for 3.3 regulation 3, if I applied for extension of load, then I have to pay, my lord, up to 11 kVA, my lord, 5,000, and up to 33 kVA, I have to deposit 20,000.
You have to go with the grievance redressal officer for this.
My lord, yes, this is the statutory valuation, because regulation is there, my lord. My lord, I think, my lord, I am running the Hassi Mill with regard that portion, that is violation of the regulation. That is why I filed the writ petition.
Learned counsel for the petitioner submits that the contract load of the petitioner was 13.16 kVA, but it was detected by the WBACTCL that excess load of 21.9 kVA was being drawn. So accordingly, on the accordingly, upon the WBACTCL informing the same, the petitioner had applied for enhancement of load. However, a quotation was raised, which according to the petitioner is in contravention of regulation 3 of clause 3 of regulation 46 of the WBERC.
Yes.
Next para. Heard learned counsel for the parties, since the matter pertains to a billing dispute, the appropriate authority is the grievance redressal officer to resolve the same. Next para. Accordingly, WPA 22133 of 2023 is disposed of by granting liberty to the petitioner to approach the GRO to decide the said issue. If so approached, the GRO shall resolve the issue independently and in accordance with law, without being influenced by any of the observations made herein, upon giving opportunity of hearing to all concerned at the earliest, preferably within 4 weeks from the approach being made. No address to cause.
May I pray for some interim order, because there is a notice for disconnection. I am paying the regular bills. I am enjoying till such.
No, you have already enhanced the load. How can
They have issued bill and I am paying that.
Liberty is also given to the actor and advocate. Liberty is also given to the petitioner to ask for interim relief before the GRO.
Grateful, extremely grateful.
Lordship.
Yes. Yes.
The next matter. It's infractions, as stand infractions. The next matter.
Every service be kept with
every service. What is the matter about? Tell me.
It's for the appointment in a post, but the petitioner has joined the college and is carrying on his duties.
Learned counsel for the petitioner submits that the cause of action of the writ petition was for appointment in a particular post, which the petitioner has already been allotted, and the petitioner is carrying on in the said post. Accordingly, the writ petition has become infructuous according to learned counsel for the petitioner. In such view of the matter, WPA 22934 of 2023 is dismissed as infructuous without any orders to cost. Yes, Mr. No, yes.
My lord, regarding item 205, Lordship was adjourned motion, my lord. I got the opportunity before your Lordship. Lordship was pleased to fix the matter regarding Hajj Yatra, my lord, 2024. It was started 29th already, my lord. If your Lordship comes some privilege, my lord.
No, is it appearing in the list?
Yes, it's 205. Item 205.
Give a notice to the other side, Mr. Strategy. It will appear under the heading fairly at the top of the upgrade list. Upgrade list on Monday.
My lord. 205.
Give us slip, just give
yes,
it.
Lord.
Item 3, fixed at 2 p.m.
I am for the petition.
But I have served through WhatsApp and email to Mr. Tas.
Yes.
Well, I don't think my learned friend will have any objection to this because it is not in respect of their property where we are.
Well,
We have also annexed a map.
So I'll keep this on record and Learned Counsel for the CSC Limited files a report where it is indicated that upon inspection, the CSC has found a technically suitable alternative service position at premises number 41 by capital H by 1, comma, Ekbalpur Lane, comma, Kolkata 7,23,000. Push-up. Since the said alternative location does not hamper the interests of the private respondents, comma, there is no scope of any resistance by the private respondents on such score. Push-up accordingly, WPA 23288 of 2023 is allowed, comma, thereby directing the CSC Limited to give new electricity service connection to the petitioner at the alternative location in terms of the report filed today within a fortnight from the date of compliance of all formalities by the petitioner. Push-up. The CSC Limited, comma, for such purpose, comma, shall raise a quotation within 48 hours.
Lordship, quotation has been already deposited.
Alternative location
No, that has not been.
within 48 hours. Push-up. Next para. It is in the event any obstruction is offered from any quarter, comma, the CSC Limited will be at liberty to approach respondent number 3, the officer in charge of the Ekbalpur police station, who will provide adequate police assistance at the cost of the petitioner. Full stop. Next para. Bas, no arrest to caution.
One thing. Only kindly note that.
I passed my order now. You should have said it earlier. I asked you specifically. Call on next.
Grateful.
I'm grateful.
Item 16.
16, yes.
Hello, I am for the petitioner, my lord.
What is the matter?
My lord, the matter is, my lord, very innocuous, but a precarious condition of the petitioner, my lord. My lord, this is the affidavit of service. The claim of the, or rather the dispute.
Food service has been affected. Service has been affected.
My lord, my lord.
Check up.
I have sent through hand delivery.
Sent or served?
My lord, both way, my lord.
The.
My lord, bar council, my lord, by hand delivery, my lord, served.
Yes, what is your innocuous prayer?
My lord, innocuous prayer is, my lord, my application. He is an aspiring advocate, my lord. After graduating in LLB, BLLB, he went and, my lord, sought to, my lord, submit his application for the purpose of enrolling himself in the role of the advocate, my lord. But he has been denied to do that.
Why?
His application has not been even received in the counter. My lord, for the reasons best known to them, my lord. But I am on instruction, I have pleaded that, my lord, he is being told only because he has been graduated from Haryana. So he has been orally asked to go to Haryana and first take the, my lord, enrollment from the state of Haryana, my lord. Some other issues there, but I cannot, my lord, submit in that way, my lord.
Despite service, none appears for the Bar Council of West Bengal or the other respondents. Pushed up. Next para. The petitioner's grievance is that the petitioner obtained a valid LLB degree and thereafter applied for enrollment as an advocate with the respondent number 1, that is the Bar Council of West Bengal. Push up. However, comma, the application was refused to be accepted on the ground that the petitioner ought to go to Haryana where he obtained his degree. Push up. Next para. It is well settled that a person obtaining enrollment in any part of India is entitled to practice in such part or any other part of the country. Pushed up. Next para. Accordingly, WPA 24203 of 2023 is disposed of by directing the respondent number 1 to accept the petitioner's application for enrollment as an advocate and to process the same expeditiously, comma, preferably within a fortnight from the date of the communication of this order to the respondent number 1. No arrest to cause urgent certificate.
Extremely grateful, madam.
I'll keep it open for the Bar Council if there is any other thing. Arakta line add kora. Needless to say, comma, it will be open to the respondent number 1 to ascertain whether the petitioner is otherwise eligible for being enrolled as an advocate while doing so.
Deeply grateful.
Thank you.
17.
I appear on behalf of CS.
Lordship, petitioner is the occupier of the premises applied for a new service connection
Service, affidavit of service?
Only CSC.
You have to file an affidavit of service.
My senior friend is appearing, Lordship.
Where is the affidavit of service? Why did
Lordship,
you
I
file
have
it?
not affirmed one.
Even if somebody is appearing,
Lordship,
you have to do
Lordship,
it.
Lordship.
Anyway, yes, what is the grievance?
Lordship, I applied for new service connection because the entire premises of the petitioner has no service connection of the CSC limit.
What is the problem, Mr. Mukherjee?
We have rejected, my lord, subsequent to inspection on the ground of splitting of load. My lord, my instruction is, my lord, if my lord may so desire, my lord, let us, my lord, do another inspection, my lord, and let us come back with a report. And
Lord Counsel, for the petitioner submits that the CSC Limited has refused to grant electricity service connection to the petitioner on the ground of apprehended splitting of load. Full-stop. Learned Counsel for the petition for the CSC Limited submits that the CSC Limited is agreeable to hold a fresh inspection, comma, if so directed by this court, to ascertain whether a connection can be given to the petitioner. Full-stop. Next para. Accordingly, the CSC Limited shall hold an inspection upon prior notice to the petitioner and file a report on the next returnable date. Do it within a week, Mr. Mukherjee. This is short.
Kindly give me 10 days time.
Push-up, the matter shall next be listed under the heading top on December 11, 2023 for passing further orders.
Lordship, one thing, Lordship.
When the report shall also be filed.
Lordship, petitioner has applied for new service connection, but they have rejected on the ground of splitting of load for a loop service.
When we inspected, my lord, we found that there is some connection is there. I will file the report.
Grateful.
I'm grateful.
18.
Yes, what is the matter?
This is my
Respondent number 3, my lord.
Yes.
I appear for the petitioners in this matter.
Yes.
This pertains to a declaration under Form A, pursuant to which a registration has been granted to the respondent number 3 association. I appear for the developer of the project. I'll just indicate in brief the facts, but I'll also point out, my lord, on the last occasion when this matter was taken up, there were two questions that fell from my lord. One was on the point of alternative remedy and how exactly would a writ lie. But I will satisfy my lord on both those points.
You are challenging what?
But I am challenging the registration. Essentially the registration, but I have also come up, my lord, by
registration of Form A.
Not for of the association, my lord.
Of the
association.
Yes,
Of Form A.
Right.
Of Form A.
Right.
Of Form A. And I've also challenged the fact, my lord, that my representation was not disposed of when I brought certain facts to the attention of the competent authority. But I'll just briefly place the facts, my lord, and I'll get on the points of law. My lord, this is a project that was undertaken, my lord, in Barasat area. There were 22 towers that were constructed, over 600 flat units within that particular township. But the project was completed in the year 2017. Completion certificates were issued by the Barasat municipality in a phased manner. But thereafter, the association or the purported association that is formed today, certain members who wanted to form it, they issue a communication under Form E to me, asking me what are the number of flats and the number of parking spaces that I have in that particular township. I duly issue a response indicating the number of flats and the garage spaces that are in my name standing as on date. But thereafter, I try to ascertain what is the status of their application under Form A that they have submitted before the competent authority. I receive no response from them whatsoever. Well, days go by, I thereafter file an RTI application before the competent authority to get a copy of Form A that has been submitted or that has been accepted. I get a copy of the Form A, my lord. I also come to learn that a registration has been granted to them by the competent authority. But on a perusal of the Form A, I find that there are several discrepancies insofar as the number of flats and garage spaces that are in my name. In fact, it's not just limited to that, my lord. The valuation of the entire land that has been given in Form A is also incorrect by at least 6 crores of rupees. Moreover, my lord, the construction nuances, my lord, insofar as the RCC and so on and so forth, my lord, those particular, the information pertaining to that is also incorrect in Form A. But I make a representation to the competent authority, bringing this to their attention. But they do not issue any response whatsoever. Even before I go to the competent authority, I in fact write to the association directly that this is what you have furnished to them. This is incorrect. Here is a comprehensive chart of the discrepancies. You kindly take steps. The association responds, my lord, and tells me that we have provided the information as per whatever you provided in your response to Form A. If you have any further grievance, you go and take steps before the competent authority. I write to the competent authority, my lord, they take no steps whatsoever. Now, my lord, on the last occasion,
My learned friend, my lord, appearing for the association, had taken up the point of alternative remedy, and my lord had also inquired as to how exactly does a REIT lag. But it will kindly take section 10A of the West Bengal Apartment Owners Act for me.
অরিত্র ওটা কি পাঠিয়ে দিয়েছো এইটার সঙ্গে আগের ফাইলটার সঙ্গে
বইটার কপি আছে?
থ্যাংক ইউ আরেকটা আনিয়ে নাও তাহলে একটা আনিয়ে নাও আছে ফেরত দিন
But I will kindly take sections 10A subsection 2 for a moment.
Yes, 2.
On receipt of a declaration or an amendment thereto or an instrument referred to in subsection 1 that is submitted by the association, the competent authority shall, after issuing notice to the parties concerned and after holding such inquiry, if any, as it may consider necessary for the purpose, examine the declaration, the amendment, or the instrument as the case may be, to ascertain whether the property concerned comes within the purview of this act, or the declaration, the amendment, or the instrument is in order.
Well, they have applied under Form A.
They have
Now,
applied under
that
Form A.
declaration that has been considered by the competent
That has been considered.
Yes.
My grievance is that I was never given a right of hearing. I was never put on notice by the competent authority. That is why my writ lies.
You say you fall within parties concerned.
Parties concerned. Because, my lord, today there are flats in my name, there are garage spaces in my name as well. I should have been put on notice. I should have been getting this opportunity of the right of an audience before the competent authority to make submissions.
So you want a redecision, not an adjudication on that by hearing you.
By hearing. Now, my lord, insofar as the alternative remedy point is concerned, my lord will kindly see 2 subclause D, my lord. This is the decision. 10A 2 subclause D, my lord.
Yes. D.
In case of rejection, forthwith communicate the order of the rejection to the owners or the owner or the owners. But thereafter, subsection 3, any person aggrieved by an order of rejection under subsection 2 may appeal to such appellate authority as the state government may by notification in the official. But so today there has to be an order of rejection that precedes my right of an appeal. Since there is no order of rejection, my lord, because I was never given a right of an audience before the competent authority, but this particular remedy does not apply to me at all.
Very well. So this is your grievance.
This is my grievance, my lord.
Let me hear them then.
Well,
yes. You are for the?
I am for the association, my lord. Registered association, respondent number 3.
What is your stand, Mr. Banerjee?
This township
No
was
seat
not
behind you. Take your seat. Yes.
This township was completed in 2016, 28 February, December 2016. As per section rule 2A, my lord, the owners or the majority of the owners are supposed to complete this process within 3 years. Initially, we have come in phases, but the developer had all the information, took no steps because the common assessment of the common areas and the collection of the common user charges, that was maintenance charges was with the developer. Took no steps for 6 years. In 2022, ultimately the flat owners, they gathered and they, my lord, gave the notice of intention under Form E to the developer. Developer has no independent existence. The remaining flats were with the developer, so they are owner of some flats. So we have to give notice under Form E to all the owners. That notice was given and we submitted the declaration under Form A. That declaration was considered by the competent authority and registration has been done. Now, my lord, the handing over is to take place. If the handing over takes place, my lord, then all the assessment and collection of the maintenance comes with the association. This is where the shoe pinches.
What is your submission regarding them not being
given a hearing? On 10, on section 10, my lord, my submission is, my lord. Yes, my lord. Hearing, my lord, it doesn't contemplate any hearing. It says
at least notice.
Notice
was
part
not given.
Notice, but I don't know. The state will not appraise regarding the notice, but the
if there was no notice, this is violated.
Yes. Then, my lord, if there's a mistake, then, my lord, rule 4 will come in. Kindly come to the rules, my lord. Rules, my lord. Rule 4 is regarding amendment.
Yes.
4, a declaration made under section 2 may be amended.
He is not exactly wanting an amendment. He's not saying amend the Form A. He's saying that Form A registration should be reopened because I was not given any hearing.
There are 2 parts. One is
so it's not an amendment of Form A. That Form A is there. Now I want an amendment. No, that exercise itself was bad. So he wants a reopening of that. So this is not.
There are 2 parts. There are 2 parts. One is no notice. The other is the declaration submitted is erroneous. So far as the second part is concerned, kindly see 4A. When there is a bona fide mistake in the declaration. So second submission is covered by 4A.
All right.
The first submission is regarding notice.
But if it is reopened on the ground of notice, then this doesn't come. Anyway, make your submission on this. Make your submission
on this. Not 4A. If not on mistake, not amendment is sought for, then the authority will consider and give their decision on that.
Can he alone make an amendment application now?
Now, that has been made by, yes, he has made the prayer before the authority. Now, the difficulty is we have submitted the Form A. We have given the declaration.
There may be ubijas IB remedium because he does not have alone probably a right to amend. And if he does not have the right to reopen also, then he is remediless.
Owner or the majority of the owners. That is the language used. Who can apply? The owner or the majority of the owners. So possibly he's not.
His grievance is not regarding his thing only. I mean, the entire thing, 6 crore and not, there are other allegations
his allegation
which
is
pertain to the entire thing.
Yes.
So if that be so, all the owners should come, or the majority at least.
But we are the majority of the owners because we are the association, we are representing all the owners except not them because they are raising the dispute. Now, the dispute is regarding some area.
You won't take up the cudgel for them. I mean, naturally.
No, because what they have done, their grievance, if your lordship goes into the facts, the common areas, garages, those have been now converted by them. They are trying to sell it.
I cannot touch the merits.
So on merits,
regarding that, there
let the state submit on the notice part. Then if anything remaining, kindly allow me. I'll just because my submission depends on that. If state has given notice, then they have no right.
to make your entire submission. Then I'll go to the state.
So my submission is first, that 10A has not been violated. So far as the second party is concerned, because hearing is not mandatory. It's the discretion of the authority. So far as amendment is concerned, regarding incorrect information, they can invoke 4A because they are some of the owners. And regarding the error that they're pointing out, that is we have submitted as per the original plan on the basis of which we have purchased the flats. Now they are trying to convert it, change it to commercially gain out of the property. This is next submission. Last submission is they are holding over to the property from 2016 without taking any steps. Although the duty of the developer is not to complete the formation of the association, they are collecting the charges and delaying the process because they are not collecting much more than the actual expenses incurred by them. So we want handover. We want speedy handover. These are
Mr. Khalif, what do you say?
Lordship, Milord, before inviting your Lordship to section 10A, Milord, may I just trouble your Lordship, Milord, with section 2 of the Act, Lordship. May I read out, Lordship? Section 2, Milord, of the Act says, Milord, this Act shall apply to every property having residential units or both residential and commercial units, and the sole owner or all the owners or majority of the owners of every such property shall submit the same within such periods as may be prescribed to the provision of this Act by duly executing and registering a declaration setting out the particular enforcement section. So, Milord, the sole owner, all owners, majority of the owners. So, what comes, Milord, section now comes at section 10 application. So, section 10 application, Milord, where Milord preferred, Milord, by this group of owners by filling up Form A. Before they file the Form A, Milord, naturally these owners, they ask the Milord, the promoters, give us the particular. He has given the particulars. On the basis of that, section 10, Milord, was preferred. Form A was filled up. Now, section 10A, Milord, that my learned friend was referring to. Milord, kindly, Milord, may I invite your Lordship, Milord, to section, Milord, 10A2, Milord. Milord, 10A, Milord, subsection 2, Milord says, on receipt of a declaration or an amendment thereto, or an instrument referred to in subsection 1, the competent authority shall, after issuing notice to the parties, Milord, may I pause for a moment? So, Milord, here parties means, Milord, is to be read with, Milord, section 2, Milord. That is all the owners or, Milord, owners that means who have come before, Milord, the authority, competent authorities.
What is the question of notice then? The applicants themselves know that they have applied. What are you saying?
As because, Milord,
it's like giving a notice to the plaintiff.
Milord, prior to that, Milord, may I just read out subsection 1 because there are a question of enquiry. In subsection 2, Milord, there is a question of enquiry which your Lordship has had in one of judgments. That enquiry is in the nature of a civil enquiry. And Milord, to challenge that enquiry, you have to go before the competent civil court. Milord,
don't take advantage of the fact that I don't remember my judgment.
I will praise that judgment. I have come up with the judgment.
Anyway, how is that relevant here?
As because, Milord, what my learned friend appearing for the petitioner wants is,
yes,
as on date, he wants, Milord, feet and substance amendment of that declaration.
Achha.
Because as per the scheme of the Act and the Rule 4, which my learned friend has read out.
So what does he have to do for that, if he wants that?
Milord, if that now, my learned friend for the petitioner, he has got the authority that is at page, Milord, 254. That association people are telling, whatever you have given, we have given to the competent authority. Competent authority.
You say that the writ petitioner can make an application for amendment?
Take up, since Milord, he is one of the owners, also claiming to be. So, Milord, kindly see Rule 5 also, Lordship.
Yes.
Milord, may I, Milord, travel your Lordship with Rule 5, Lordship?
Yes, please.
When in any of the circumstances under stated in Rule 4, Milord states the circumstances, Milord, under which any of them can pray for Milord amendment to the Milord Form A declaration. Any amendment is to be made in the declaration submitted under subsection 1 of section 10A by the sole owner or all the owners or majority of the owners of any property, such sole owner or all the owners or such majority of owners, as the case may be, shall submit to the competent authority a fresh declaration in Form A, superscribed amended declaration, incorporating therein the amendment asked for in place of the portion to be amended. Such fresh declaration shall be accompanied by an application for amendment in Form B, stating clearly the circumstances necessitating such amendment and also the amendment to be made in the declaration sought to be amended. So, Form N, application for amendment, followed by another Form A with the superscription that it is an amendment. Milord, kindly sees the representation which my learned friend has also preferred before the competent authority, Milord, annexed at page 255 of your Lordship brief, Milord, and kindly sees the concluding part of that particular representation, Milord, at Milord, page 258. At page 258.
Yes.
Therefore, our clients request your good office to take cognizance of the issue and make necessary changes, amendments in Form A, submitted by so and so. That is the name of the association in abbreviation in terms of Apartment Ownership Act within 7 days, so and so. And this authority they are exercising by virtue of page 259, where association has given him the power. Yes, you go and agitate the issues.
Mr. Galib, you are for the competent authority also.
Lordship.
So you don't have any objection if this amendment application, then you say they can make this amendment application?
If they come under Form N, application for amendment under
They can do
Form
it tomorrow. In fact, I can give them leave. They will make an amendment application, seek the same relief, then you decide that. Yes.
Form N. So many they can, since they are also claiming to be the owners, not promoters.
What about the notice not being given to them?
Milord, these are with regard to Milord. Kindly sees, I was willing to read out, Milord, before reading out 10A to Milord, I was, Milord, willing to read out, Milord, 10A1 also, Milord. Milord, may I travel your lordship with 10A1 once, Milord. Any declaration referred to in subsection 2 or amendment thereto or any instrument referred to in subsection 3 of section 4 shall in the first instance be submitted by the sole owner or all the owners or majority of the owners of the apartments in duplicate within 30 days from the date of its execution to the competent authority, along with copies of site plans, building plans, and a notice of intention to submit the property to the provisions of this act. This notice of intention is Form E. This is Form E, which my learned friend has obtained from my learned friend for the petitioner. So, Milord, since Milord, it is concerned with Form E and Form A, so Milord, notice if any Milord is only to be given to persons Milord who are or who have Milord have come with Form E and Form A. How can they be regarded as the necessary parties, Milord? These are my Milord, is my respectful submission subject to your lordship correction. So, as on date, my respectful submission, your lordship has two judgments on this issue specific. Lordship, I don't want to.
What issue? Which issue?
One, your lordship was pleased to hold in one judgment that this inquiry, which is contemplated, Milord, in section 10, subsection 2, this inquiry is, Milord, in the nature of civil inquiry.
That is not German in this matter.
As because, Milord,
yes.
Subject to your lordship correction.
Hmm.
Here, declaration is preceded by an inquiry. What is the inquiry about, Milord? Inquiry about all the particulars, Milord, which are, Milord, given in, Milord, Form A. So, Milord, Form A comes from where, Milord? Form A comes from Form E. What is Form E? All the details of garages, flats, common spaces, limited common spaces. So, these are the subject matter of that inquiry. After inquiry, Milord, then declaration is allowed and the association applicant is directed, you go and get it registered before the registry. So since my learned friend for the petition is hitting upon that inquiry part, Form E particulars followed by Form A particulars. So these are my submission.
Yes. If I may respond, Manoj.
Yes.
Well, at the very first instance, I'll be taking up the submission made by my learned friend insofar as 10A2 is concerned, that only a party who's submitting the declaration on the Form A is
But
entitled.
you have asked for amendment in your representation.
But it's not an amendment. But I will kindly take Rule 5 for a moment.
No, your application, your representation says.
I have seek for an amendment because I can't make a formal application under the rule. But I will kindly take Rule 5 for a moment. It says when in any of the circumstances stated in Rule 4, any amendment is to be made in the declaration submitted under subsection 1 of section 10A by the sole owners or all the owners or majority of the owners of any such property, such sole owners, the word such is important over here because it is the party who is making the declaration who is entitled to come up and seek an amendment. Now, if what my learned friend is contending that I am entitled to come in for an amendment under Rule 5, I'll go ahead, I'll give my application for amendment. I have no difficulty. But Rule 5 would otherwise indicate that only the party who has submitted Form A is entitled to come forward for an amendment. And now, my lord, insofar as my learned friend's submission is concerned, that only a person who has submitted Form E or Form A is entitled to hearing, my lord, if I may just respond to that for a moment. But if that be the case, then essentially the act as interpreted by my learned friend would hold that the majority can act with prejudice to the minority, to the prejudice of the minority. So if I have numbers, I can come forward, I can give certain information and I can get a declaration. But what if incorrect information is provided, which is exactly what has happened in this present case? So am I not entitled to a right to an inquiry, which is exactly why my lord 10A2 comes into the picture. That an inquiry is given so that all concerned parties, which would mean all owners of the apartment township, my lord, and not limited only to those who have submitted an application before the competent authority. Because to do that, my lord, would not serve the purpose which my learned friend has already, my lord, put forth, which is to ascertain whether or not the declaration, the amendment, or the instrument is in order. How is he, my lord, how will an authority ascertain that if there is no adjudication to that effect? Because the party who will make the form will say, no, it's in order.
The petitioner is one petitioner.
Well, two petitioners.
The petitioners are the developers in respect of an apartment which is comprised of several towers. Push up next para. The towers were constructed phase-wise, it is submitted. Push up. The grievance of the petitioners is that without prior notice to the petitioners under section 10 capital A within bracket 2 within bracket small a of the West Bengal Apartment Ownership Act 1972, Form A was accepted and the association was registered. Push up, it is submitted that the present petitioners have several grievances against such registration, since the declaration and Form A deviate from the factual scenario in the said apartment on several major aspects. Push up. Next para. Learned counsel for the respondent association submits that the writ petition is not maintainable in view of availability of an equally efficacious alternative remedy in the form of an appeal under section 10 capital A within bracket 3 of the 1972 Act. Push up next para. Such point, however, is controverted by learned counsel for the petitioner by arguing that in the present case, there has been no order of rejection as contemplated in the said subsection to permit the petitioners to prefer an appeal. Push up next para. Learned counsel appearing for the respondent association further submits that whereas the apartment was built in the year 2016, the petitioners stroke developers were deliberately delaying the matter of registration of the association to commercially exploit the property. Push up next para. It is submitted that the present application is also factually incorrect insofar as the association, upon furnishing proper details, obtained the registration of the same. Push up next para. Learned counsel for the competent authority controverts the submissions of the petitioners as well. Push up. It is argued, by placing reliance on section 2 of the said act, that the act applies to every property having residential units or both residential and commercial units, and the sole owner or all the owners or majority of the owners of every such property shall submit the same within such period as may be prescribed to the provisions of the act. Whose sub next para it is submitted that the association duly submitted under the provisions of section 2 read with section 10 of the 1972 act, and as such, comma, the said chapter cannot be reopened. Full stop. Learned Counsel also seeks to submit that the that under the contemplation of subsection 2 small a of section 10 capital A, comma, the notice is to be issued to the within double inverted parties concerned, double inverted close, comma, which refers to the applicants who presented the Form A stroke declaration. Sub next para, read in conjunction with subsection 1 of section 10 capital A, comma, the same is the only plausible construction possible. Sub, it is argued that the inquiry contemplated in subsection 1 of section 10 capital A is the nature of a civil and is in the nature of a civil inquiry, which having been done in the present case, comma, the remedy of the petitioners, comma, at best, comma, would be to seek an amendment of the declaration. Sub next para. Learned Counsel also places reliance on rules 4 and 5 of the West Bengal Apartment Ownership Rules 1974 in such context. Full stop next para. In reply, comma, Learned Counsel for the petitioners adds that Rule 5 envisages that an amendment has to be sought by the applicants who made the application, who made the declaration in the first place. First up, by placing reliance on the language of subsection sub-rule 1 of Rule 5, comma, Learned Counsel for the petitioners reiterates such submission. First up, next para. Upon a perusal of the materials on record, comma, it transpires that there is nothing on record or apparent from the submission of the parties to indicate that any notice was given at any point of time under section 10 capital A within bracket 2 within bracket small a of the 1972 Act. Pushed up. Insofar as the submission of the competent authority is concerned, to the effect that the parties concerned contemplated in subsection 2 within bracket small a only speak about the applicants themselves, comma, the same would be an absurd interpretation and cannot be accepted. Pushed up. It would be somewhat like issuing a summons to the plaintiff himself. Pushed up. Next para. Obviously, comma, within the contemplation of the inquiry as envisaged in section 10 capital A within bracket 1, comma, read in conjunction with the notice under section 10 capital A within bracket 2 within bracket small a, comma, the notice has to be issued not to the applicant within bracket as is evident from the language of the said provision itself, bracket closed, but to the italic say parties concerned. Full stop. Next para. The said expression is immediately suffixed by the phrase within double inverted after holding such inquiry, double inverted close, dot, dot, dot. Push up. Hence, comma, it is clear that all parties who are affected by such registration or acceptance of the declaration and the Form A are required to be given notice prior to deciding on the same. Push up. In the present case, comma, since such notice has not been given to the petitioners, comma, the petitioners are justified in arguing that the acceptance of the declaration and Form A and registration of the association itself is perverse. Sub next para, insofar as the argument as to non-maintainability of the writ petition is concerned, comma, the same also does not hold water, comma, since section 10 capital A within bracket 3 as rightly contended by learned counsel for the petitioners, comma, envisages a situation where a person is aggrieved by an order of rejection under subsection within bracket 2 That is when the competent authority refuses to accept the declaration or register the association. Full stop. In the present case, comma, the converse happened, for which the petitioners are not entitled to prefer any appeal. Full stop. Also, comma, as correctly submitted by the petitioners, comma, Rule 5 of the 1974 rules makes it clear that within double inverted such sole owner, double inverted clause, comma, which refers to the expression double inverted sole owner, double inverted clause, used in the preceding part of subrule 1 of rule 5, comma, refers to the sole owner only in cases where a sole owner presented the declaration as envisaged in the said act and rules. Full stop. Next para. In the present case, comma, the majority of the owners, comma, for the purpose of forming the association, comma, had made the initial application stroke declaration, due to which the present petitioners, comma, in the capacity of sole owners, comma, do not have a right to reopen the issue by seeking an amendment. Full stop. Next para. Lastly, comma, although the expression uh, within double inverted amended double inverted was used in a stray manner in the representation of the petitioners, comma, the crux of the dispute raised by the petitioners was that the petitioners were never given any notice before the declaration was accepted and the association registered. Full stop. Although the petitioners seek to raise certain salient issues regarding the declaration itself, comma, the writ court is not the forum to go into such issues. Full stop. In any event, comma, in view of the above circumstances, comma, the acceptance of the declaration and the registration of the association itself is vitiated and ought to be set aside. Full stop. Accordingly, WPA 25143 of 2023 is allowed on contest, comma, thereby setting aside the decision of the competent authority to accept the declaration and Form A submitted by the respondent stroke association, as well as the registration of the association consequent thereto. Full stop. The competent authority shall revisit the issue by redeciding on the Form A and declaration submitted by the respondent association by giving a prior notice to all concerned, comma, including the present writ petitioners. Full stop. Upon such notice being adequately given, comma, an opportunity of representation and hearing shall be given to all concerned, including the petitioners, and a fresh decision in that regard shall be taken by the competent authority. Full stop. In view of the anxiety of the respondent association in the matter of delay and apprehended commercial exploitation, comma, it is expected that the competent authority shall complete the entire exercise of redeciding as expeditiously as possible, comma, positively within 6 weeks from this date. Within 8 weeks from this date. Full stop. No arrest to cause.
Kindly make it 6 weeks. We are suffering for a long time.
Will they be able to do it?
Authority can.
8 weeks.
8 weeks. But I'm denying all the factual allegations that they
Since
how can he's
no,
the petitioner.
they are denying the factual allegations we have.
factual allegations.
Insofar as no affidavits have been called for, comma, it is deemed that none of the allegations made by the parties against each other are admitted.
No, but insofar as the commercial exploitation and
None of the allegations made against each other are admitted.
Because of this mistake, we are suffering because once it comes over to the
Undoubtedly, you are suffering. There is no doubt on that.
Grateful.
19.
Yes.
Lordship had directed us to serve one of
Yes, Mr. Chaudhary.
This is challenging a willful defaulter action. Identification committee, review committee, both forums I have lost. But the point of challenge is very small. Well, the only document which has been relied by the bank to classify me as a willful defaulter is a forensic audit report, which has not been given to me at any stage in spite of repeatedly asking for it. This is the only ground of challenge. I'll show your Lordship the 5 pages, relevant pages. At page 28, Lordship will come. It's the show cause notice. And second reason is also there. The contention raised, Lordship will find it's a cryptic order. It has not considered my page 28 is the show cause notice. The allegations are, Lordship will find at page 29, para 5 allegation. During our internal review, it is observed you have continuously defaulted in payment obligation and violated agreed terms and has acted in a manner as under, which is deemed to be act of willful default as per RBI guideline. Now kindly see the main act, and this is and the only act that I have been condemned of is unit has defaulted in meeting payment obligation to the lender and has not utilized the finance from the lender for the specific purpose for which finance was granted. And on the right hand side, Lordship will find out of total payment of so and so, which constitute 11.86, amount has been paid to non-corporate entities. Year-wise breakup of fund transferred to non-corporate entities is as follows: 2011-12 to that. And then 6 is bank has documentary proof consisting of forensic audit in this regard. Therefore, it is observed your act falls under that. So allegation is that it is willful default because I have disbursed the money to non-corporate entities, and the proof is that I have a forensic audit report. I reply to this, Miller. The first reply is at page 32. It's a very general reply. Then when they call for hearing, Miller, I give a detailed reply, which Lordship will find at page 37. At page 37, I give a detailed reply before going for hearing. Page 37.
Yes.
29 July 2021. Lord, I will not trouble your Lordship with the details I have said. Two things kindly come to page 41, para 4. I have not been provided with the purported evidence placed before the identification committee, by virtue of which the said committee has come to the conclusion that evidence of default has occurred in the account of the borrower company, which is willful and substantial to classify the undersigned as willful defaulter. In the absence of such document, undersigned was never provided the opportunity to make a meaningful submission. Yes. I say undersigned seeks the particulars of the following: name of the parties, funds, reason why you are holding so and so. And another paragraph I would like to show your Lordship. And in this reply at page 43, I also quote the judgment that
developers.
Developers, Atlantis, kindly see page 43.
Yes.
Delinquent must have the entirety of the materials that were placed before the identification committee to give a meaningful submission. And para 7, I want to show your Lordship. 7, 8, I want to show. We call upon you to point out which part or portion of the circular of 1st July provides that payment to non-corporate entities is disallowed or barred or will be deemed to an act of willful default. It is further relevant that none of the sanction letters of the bank or documents executed between the bank and the company prevent or bar or restrain the company from making any payment to non-corporate entities. And then, I on my own at page 45, para 12, I give the particulars as per my party ledger that I have made payment to these people, non-corporate entities, but this is the purpose. Para 12, I give the name, and para 13 at page 47, the transaction detail, I only give it.
Not considered.
Nothing. It is in supply of my business. Kindly see, Adi Sale, supply of MS Beam, Akash Enterprise, supply of High Mast, Allied Electrical, supply of industrial cable. I can't only deal with companies. It may be a proprietorship firm, it may be a partnership firm, and I give the detail. And then, my lord, comes the identification committee. And para 14, I must show your Lordship. I have also given the proof of the documents. Para 14, copies of document demonstrating the genuineness of the transaction between the company and non-co will find established transactions were usual and normal. Said documents being Annexure C comprises of bills, vouchers, invoices, challans, GRN. In this regard, it is relevant. Annexed hereto are not complete. Many more documents if genuineness of the transaction. They don't question this. Then comes, my lord, the identification committee report. Order, sorry, page 45. Page 55, I'm sorry. 58. It's a cut and paste of the show cause notice. Committee observed the following: corporate borrower has committed the following act of willful default. What I read from the show cause notice in the tabulation is a cut paste. Those 7 years have been mentioned. Amounts mentioned. 11, kindly see 11.86% of the total amount have been paid to non-corporate entities. And the same thing. And then, my lord, after that, since the bank has direct proof of diversion of fund by the borrower and its directors who are in charge, proof not given.
Review committee.
Then, my lord, I give a representation to the review committee also. The representation, page 57 is the representation. In the representation, my lord, I annex the earlier letter as annexure A, which is, my lord, Lordship will find at page 60 at the bottom. And I also said that all, page 60, clause D, my lord, all non-corporate entities, legal entity with good repute and completely non-related to the borrower and guarantors. I also say that. And then, my lord, the same representation is given. The review committee, my lord, page 77.
Review committee order is more reasoned. Page 78, there are reasons.
My lord, I shall show, my lord. In fact, it's a more cryptic order, no reason. We had communicated, page 77, communicated to you with a letter of so-and-so that identification committee has declared you as willful defaulter, and the review committee on classification will review the said order and take a final decision on confirming the order. It was also communicated to you with a above letter that if you desire to make any submission to review committee passed by IDC, you may do so within 15 days. Now we wish to advise you that the reply representation submitted by you dated 7 January has been considered by the review committee. Some of the observations of the committee are as under. Forensic audit proves that there is diversion of fund. Corporate debtor has not submitted any documentary evidence substantiating their claim that the payments made to non-corporate entities were in line with the purpose with credit facilities were sanctioned. Entire detail has been given. And this is a new reason which is coming. And the only document, forensic audit report, not supplied at any stage. Insufficient recovery action by the borrower against Jain International for non-supply under the terms of advance payment. Review committee has come to the conclusion so and so. Lordship has seen, my lord, the finding of the first committee or identification committee was copy paste of the show cause notice, and bank has direct proof of evidence that you have diverted fund. And when I go to the review committee annexing the same and I give my letter, none of it is considered, that these are not genuine transaction or this transaction is not for the purpose of the loan. Well, these are my two.
Yes, sir.
And the judgment, my lord, Atlantic projects, my lord, one paragraph I show you, lord. Page 36, paragraph. I'll give you mine.
No. Okay, thank you.
Lord, this Atlantic, my lord, it was page 36, lord, she will.
Yes.
And 10th line from the top. Clause 3B requires application of mind by the identification committee at all stages. It is required to apply its mind on the contents of the show cause notice, also as it is a crucial stage in the whole process. The delinquent must have the entirety. This is the line which I had quoted in my reply. The delinquent must have the entirety of the materials that were placed before the identification committee for the delinquent to give a meaningful submission. Right of oral hearing is not automatic. This point I am not on. Only on this point. Not those are.
Yes.
Lordship, my first submission before your Lordship, though it's technical, your Lordship, but I would like to draw your Lordship kind attention that when the matter was initially taken up by your Lordship on 20th, subject to correction, and that relevant point of time, the petitioner has moved the application, and your Lordship has observed that despite of service, none appears. But the fact remains, the petitioner served the copy to the bank with an intimation it will going to appear on 21st.
Achha.
So though that is technical, but but if on that particular day, if your Lordship take any cognizance, I'm on that. But see, he should at least intimate the bank. It is on 20th. It is Lordship, because of that representation, Lordship has to take a view that none appears despite of. But the letter shows 21st. First. Second point, your Lordship, there is no dispute on the part of the petitioner that they have received a show cause notice. They have participated in the process. They have given a reply to that.
that on the basis of that reply, personal hearing opportunities has also been availed. These facts is not in dispute. And thereafter, the identification committee has passed an order on the basis of that, that because of this, Lordship kindly come to the identification committee order. From there, your Lordship will find that the so-cause notice, in the so-cause notice, bank has informed the petitioner that because he has found guilty of diversion of fund amounting to rupees 8,898 and odd. In their reply to so-cause notice, they have not corroborated to substantiate that the amount as indicated in your so-cause notice is not correct, because we have paid this amount to these persons. These are the slips of that. Only mere saying disclosure of the party's name will not suffice, because our specific allegation was the amount of rupees 8,898 lakhs you have diverted out of the total fund, which has not been corroborated. Save and accept mere denial. I have not diverted, and simply given the particulars. Even the particulars which they have given, they are saying these are the documents we have, rest of the documents in CIRP process. And so far as the forensic audit is concerned, which the bank has not supplied to the petitioner, the reasons for that, your Lordship, the CIRP process has against the petitioner has started before the NCLT. Now the company is in liquidation, and in that liquidation process, the resolution professional has called a meeting. In that meeting, on the basis of decision of CIRP, the committee of creditors, a forensic auditor has been appointed. And that forensic auditor who has been appointed, the petitioner has given full chance to participate in the process of discussion about the forensic audit report. They have a question by the committee of creditors and the forensic auditor. Can you explain the diversion of this fund? There was no satisfactory answer to that. On the basis of that, on each and every, I have a minutes to that effect, that they have participated in the process. And this fact has been suppressed before the Honorable Court, that I did not get an opportunity to go for the forensic audit relied upon by the bank. Now, why the bank has not supplied the forensic audit report, the basis of that, your Lordship, since the petitioner has also participated in the entire process of forensic audit report discussed before the committee of creditor in presence of the petitioner.
The copy was given in that proceeding to them.
In that proceeding, every entry has been discussed with them. They have not asked for. They have not asked for. I have a minutes prepared by the resolution professional right now with me. But all these facts has been suppressed in the writ petition. So writ petition is also bad for suppression and misrepresentation of facts. What was prompted the petitioner not to disclose all these facts in the writ petition? I have participated in the bid process, forensic audit report discussed over there. I have not been handed over. Moreover, he is a defaulter, the petitioner defaulter more than 10 financial institutions. More than 90 crore is due and outstanding to more than 10 financial institutions. So if I am seeking for a relief on equitable ground, I must be approach the court with clean hands. That these are the facts, these are the forensic audit report. I have participated. Even NCLT resolution professional, despite of my repeated request, has not handed over. This is not his case. Rather, he suppressed all these facts. And hammering on the technical ground, I have not been. But the per contra, even the submission right now, your Lordship the petitioner has submitted before your Lordship. They have failed to a single scrap of paper. Even the writ petition, they have failed to corroborate what documents they have produced. Why they have not annexed those documents over here? To substantiate the fund of rupees 8,890 crores out of the total exposure has been siphoned. So Lordship, this is the suppression of fact. And so far as the Lordship minutes are concerned, I am having. If your Lordship say, I will produce before your Lordship. And there is undisputed. They have participated, duly represented on each and every occasion.
If hair was not given to them.
Lordship?
If hair was not given to them.
Yes, because of the reasons for that, your Lordship, I have taken instruction. The bank has given a non-disclosure of the documents
in the committee of proceeding, minutes of that proceeding here.
The minutes of the proceeding
is it relevant even?
The relevant in the sense, Lordship, the forensic audit report on the basis of which the bank has issued a so-called notice.
Components might have been discussed there, but they do not know what is the document on the basis of which this was done.
Lordship,
so the CIRP proceedings are a different proceeding altogether.
I am not on that. I am not on CRP process. I am on the point that the bank has relied upon the forensic audit report.
Maybe.
They are also asking for a forensic audit report. And they were the piece and parcel in the committee for discussion over the same. They did not ask for there, be that as it may. Your Lordship, if they are so desire want to, I am supplying with the leave of the court, I am supplying. Let them give reply before the committee, Because Sokas notice has no point of time.
I'll formalize it. I'll formalize your supplying by setting aside the order and
Lordship, may I? Subject to your Lordship, obviously.
Definitely, you'll give a copy to them.
Lordship, my
just formalize it by passing an order.
Lordship, my only submission before your Lordship is that Sokas notice reply to that. The decision of the first committee has not been challenged at any relevant point of time.
So when they challenge, we say go to the review committee. That's why they've not challenged, rightly so.
Let's say I leave it because this
that would be the first objection you would have taken, and we would have probably sustained also.
But they are aware. But in the RBI guidelines, even a default can be a ground for declaring him as a willful defaulter. There is no dispute. He is not a defaulter. There is no dispute. The company is in liquidation. There is no dispute. He is the guarantor and promoter.
No dispute regarding that. But regarding the RBI Master Circular grounds being satisfied, they are disputing, obviously.
They are disputing, but the fact remains dispute for litigation purpose, actually suppressing everything in the writ petition.
No, I'll just direct the matter to be reheard by the identification.
Lordship, I leave it to you, Lordship. These are my submissions, Lordship.
Learned counsel for the petitioner contends that, learned senior counsel appearing for the petitioner contends that the petitioner was declared as a willful defaulter by the identification committee and thereafter by the review committee, dehorts the provisions of the RBI Master Circular and the principles of natural justice. Post of next para, it is submitted that the relevant documents on which the bank relied for so declaring, primarily the forensic audit report within bracket FAR, bracket closed, were not supplied to the petitioner at any point of time, despite the petitioner having pointed out the same in the petitioner's objection. Full stop, next para, objection to the show cause. Full stop, next para, that apart, it is contended that the orders of the willful defaulter identification committee as well as the review committee are cryptic in nature and do not refer at all to the documents produced by the petitioner and or the arguments advanced by the petitioner. First up, next para, learned counsel places reliance on a judgment of a coordinate bench of this court rendered in Messrs. Atlantic Projects Limited and others versus the Allahabad Bank and others. Full stop. Learned counsel appearing for the bank contends that although it was recorded in the order dated November 20, 2023 that despite service none appeared for the bank, it had been intimated to the bank that the matter would be taken up on the next day, that is on November 21, 2023, whereas the same was heard on November 20, 2023. Hence, it is pointed out that the bank did not have an opportunity to controvert the matter at the relevant juncture. Next para. It is further submitted that the petitioner was fully aware and participated in a CIRP process with regard to the borrower company, where each of the components of the concerned FAR were discussed threadbare. However, such facts have been suppressed by the petitioner. Learned counsel for the bank contends that he has a copy of the minutes of the said proceedings and is agreeable to produce the same if so directed by the court. Next para, learned counsel for the bank also points out that the petitioner is a defaulter, is a defaulter in respect of at least 10 financial institutions to the tune of more than rupees 90 crore. It is argued that the petitioner, having not come with clean hands, ought not to be permitted to move the present writ petition. Next para, learned counsel for the bank further submits that the petitioner never challenged the order of the first committee and as such ought to be precluded from moving the present challenge. Next para, a perusal of the ratio laid down in Messrs. Atlantic Projects Limited indicates that the learned single judge observed that right of oral hearing, that
the delinquent must have the entirety of the materials that were placed before the identification committee IC capital for the delinquent to give a meaningful submission. Full stop. Abiding by the said principle, comma, which is also a cardinal principle of natural justice, comma, since a man ought not to be heard without getting full opportunity to address all materials on which he is indicted, comma, we find that in the present proceeding, neither the FAR nor other relevant documents were served on the petitioner at any point of time by the bank. Full stop. Next para. The arguments of the bank regarding the components of the FAR having been discussed in a corporate insolvency resolution process is neither here nor there. Full stop. Such within double inverted discussion, double inverted close in a minute recorded in connection with such process does not amount to service of a copy of the FAR on the petitioner at all. Push up. Moreover, comma, it is not the case of the bank that even in connection with the said CIRP, comma, any copy of the FAR was handed over to the petitioner. Push up. Thus, comma, the point remains that the documents which were crucial for coming to the conclusion of willful defaulter were never handed over to the petitioner by the bank. Push up. I find from a perusal of several paragraphs of the objection to the show cause, comma, given by the petitioner, that the petitioner categorically pointed out that the purported evidence placed before the identification committee, comma, by virtue of which the said committee had come to the conclusion that evidence of default has occurred in the account were never served on the petitioner. Full stop. The petitioner also pointed out that in the absence of such information and documents, comma, the petitioner was never provided the opportunity to make a meaningful and effective representation to the allegation of willful default. Full stop. It is further seen from the objection to the show cause and the representation before the review committee given by the petitioner that detailed particulars of several transactions of the petitioner and supporting documents were placed by the petitioner before the said committees. Push up. However, comma, unfortunately, comma, the none of the said pleadings or documents are reflected in the order of the identification committee or the review committee. Full stop. The first committee, comma, as rightly contended by the petitioner, rendered a cryptic order, comma, finding the petitioner to be a willful defaulter. Full stop. The bank merely stated, comma, by copying the contents of the show cause, comma, that it has within double inverted direct proof, double inverted close, for diversion of funds by the borrower and its directors. Full stop. Next para. Neither the said perceived direct proof is referred to categorically, comma, nor is any particular thereof being given in the said order. Full stop. The review committee tried to improve the cryptic nature of the first committee order to an extent by attributing three apparent reasons in addition. Full stop. The first reason was, comma, however, comma, that the forensic audit report proves that there is diversion of fund, comma, which takes us back to the first submission of the petitioner that no copy of the said document was given to the petitioner at any point of time. Push up. Next para. The rest of the allegations refer to perceived irregularities by the petitioner, comma, without adverting to in specific terms or even vaguely the specific details and chain of transactions disclosed by the petitioner in his reply to the show cause. Push up. Thus, comma, the order of the willful defaulter identification committee and as affirmed by the review committee suffer from patent violation of principles of natural justice and suffers from utter paucity of reasons. Full stop. Next para. Moreover, comma, the relevant documents and pleadings of the petitioner were never taken into consideration. full stop. On such grounds, comma, none of the said orders can survive the scrutiny of judicial review. Accordingly, WPA 25317 of 2023 is allowed on contest, thereby setting aside the orders of the willful defaulter identification committee and the review committee, whereby the petitioner was held to be a willful defaulter. Full stop. The first committee, that is the willful defaulter identification committee, shall now proceed on the basis of the show cause notice initially given to the petitioner by furnishing to the petitioner the forensic audit report as well as all other documents on which the petitioner seeks to rely in support of its allegation of willful defaulter. Full stop. Next para, upon such copies being furnished to the petitioner and an opportunity of hearing being given to the petitioner, comma, the willful defaulter committee shall revisit the issue and decide on the question as to whether the petitioner can be declared to be a willful defaulter under the relevant master circular of the RBI. Full stop. No orders to cause urgency.
So only subject to correction. Let's see. I have submitted 90 crores. It would be 900 crores. Let's see. I have down page.
Zero at crores.
Well, in
Obliged.
one place, Lordship has of that penultimate paragraph, all the documents the petitioner wishes to rely, it should be the bank wishes to rely.
Yes, right.
And my lord, only other thing, my lord.
Wait. The petitioner wishes to relate to WPA revisit the issue. All the documents on which the petitioner seeks to rely. Yes. What is?
My lord, so far as the service aspect, my lord, let my learned junior clarify.
My lord,
He's perhaps not-
this matter appeared on 20. It was to be listed on 21st, which was a holiday. It, my lord, automatically appeared on 20th.
Since I dismissed his application,
My lord, I indicated since bank is not here, I will serve him again and then move it.
I'm having the letter. I'm not saying on the Westland.
Yes. Next.
But say instead of 99, 900 crores.
900 correction has been made. The other correction I'll.
Obliged, Your Lords. Obliged.
What is it?
Original side matters.
My lord.
Put up.
One second. Half a second. Hey, yeah, Pradip Bagushu.
My lord, I filed
Original side.
Original side.
Yes.
My lord, I filed a writ petition, my lord, challenging the illegal declaration of my account as NPA, my lord. The bank is taking precipitative steps, my lord, and my writ would become infructuous, my lord, if it's not heard, my lord. I'm just praying, my lord, if it
It is
can.
appearing in the list.
No, my lord, it's filed yesterday, my lord. I have served a copy on the bank, my lord. My lord, may kindly fix it up on Monday, my lord, subject to convenience of the court, my lord.
Where will Monday at the top?
Grateful, my lord.
Yes.
May I mention, my lord? My lord, one matter running in the list, my lord, in today's list, item number 25, my lord. It is part-heard matter, my lord. And
I'll take up in due course. Let me dispose of these matters first. Every day there is a 3:30 and I cannot take up these matters. Let me call on the list. Yes.
Item number 1, Griham Food and Hotel Private Limited versus Union of India and others.
Yes, Mr. Vats.
Please, Your Lordship, I appear for the petitioner led by Mr. Kishore Dutt. The writ petition is principally directed, IRCTC had a policy, previously the catering policy was of 2010. In terms of the 2010 policy, sometime in 2014, this petitioner was allotted, in respect of 5 different trains. We are in the writ petition, 5 different trains are in issue. Different trains allotted to the writ petitioner for catering in terms of the 2010 policy. During the interregnum, this is ordinarily for 5 years. Ordinarily for 5 years, extendable by another 5 years on terms indicated in the 2010 policy. And, my lord, there is a subsequent policy of 2017. Now, rightly, wrongly, my lord, whatever is obligatory on my part towards this license fees or whatever the fees are, extendable, increased, those have been complied with by the petitioners. in respect of all the trains. Now, suddenly, they are saddling us down by page 41 of the writ petition. That is the subject matter of the writ petition immediately. This is addressed to my client. Demand notice for revised license fee, post-sale assessment in lieu of, kindly marks this, CC 60 of 2019. Reference, there is a reference, there are references to two independent letters, 8th April 2022 and 8th February 2023. My lord, gets it, my lord?
Yes.
Those letters, my lord, kindly marks by pencil, my lord, or my lord, whatever, 48 and 51. 48 and 51. Those two letters.
Yes.
My lord, are at pages 48. The first one is at page 48. My lord, please see page 48. আমাকে দেন নেই তোমার কাছে আছে তুমি করো
Yes, page 48.
This is addressed by the IRCTC to the group general manager of Eastern Zone, Northern Zone, Western Zone, South Central of IRCTC. This is modalities for assessment of sales in Mail Express and RSD and TSV trains for revision in license fee contracts in lieu of CC 60 of 2019. CC 60 of 2019 was issued on the 14th of November 2019. Page 362 is the relevant page. 364, sorry. It is in the 4th volume of the papers.
Yes.
CC 60, your lordship will find reference everywhere. I request your lordship to kindly come to Annexure P15, page 364. That is, CC 60.
Mr. Bhattacharya, please indicate what will be your point.
My only point is,
yes,
since I invited your lordship first to page 41, please fall back to page 41.
41, yes.
In reference to the above, after the reference, in reference to the above.
Why do you say you are not required to pay this?
Because, in terms of the policy decisions, I have already paid the increased license fees. Whatever
10 and 2017
yes,
policy.
yes. Whatever was obligatory for me. It was incumbent for me to pay X plus 1. I have paid them. That amount is complete. They are now, pinning us down by page 41 and, completely beyond jurisdiction. They are trying to extract an amount which is not envisaged in the CC 60 policy. It is not envisaged anywhere. Apart from that, whatever was obligatory for me to pay, I have paid. Even the enhanced license fees has already been paid. It's not that there is any dispute regarding that. Now they are saying that please pay in terms of CC 60, which per se do not contemplate any increase. Apropos the policy, if your lordship looks at 2010 policy, then the 2017 policy, we were all appointed sometime in 2014 and onwards. My senior is.
All right, yes.
Page 41, CC 60.
So Bhattacharya was saying that there is no basis to this.
Yes, yes. Yes, this would be my submission. The bottom line is, the central government runs the railways.
Yes.
Now to run the railways, certain infrastructures are required. Certain facilities are to be provided to the passengers, others, etc. Now, the catering in the running trains, is part of the facilities or amenities that is given to the passengers. Now, why I say this, because since the railways is the authority to run the railway, or the only authority to run the railway, IRCTC cannot exercise any right unless it is specifically conferred upon them by the railway authorities. In this case, the railway board. This will be my first leg of submission. My second leg of submission would be that this conferring of power on the IRCTC did not, by the railway board, did not include the power to revise the license fees based on tariff, change in the tariff. And third, which is very important, is if my lord may kindly come to page 41. Now, please take me to the second paragraph. 41 to police. Yes. But if I may read from the first paragraph, or the subject itself. Demand notice for revised license fee for post-sale assessment in lieu of CC60. In lieu of. Now, again, to scuttle CC60 or to ask for something in place of, in lieu of, we mean in place of, again, there has to be a power conferred upon the IRCTC that you can ignore CC60 and claim something based on sales assessment. Now, may I read the second paragraph? Further, on issuance of the instructions from so-and-so, video letters under so-and-so has calculated the revised license fees on the basis of assessment in post-paid SBD and non-SBD trains in lieu of CC, etc.
Yes.
Now, may I, now take your lordship through the relevant circulars, which are operating in the field. I was selected at a stage in the year 2014 when, the catering policy of 2010, was in operation. Now, if your lordship may kindly have a look to the catering policy of 2010 at page 313. Yes. In the third volume.
Yes. The 2010 policy.
This is the 2010 policy, which was prevailing when I was selected for the first time for 5 years license,
right,
which was granted to me. Now, first kindly take clause 3.2 at page 314. This we are on license fee, which is based on menu and tariff. I will only place those relevant clauses.
Yes, right.
Please take 3.2 at page 314. Railway board shall determine the menu and tariff for the standard meals, breakfast, tea, coffee, and catering charges for meals, etc., which are included in the fare. Zonal railways will determine the menu and tariff for all other items, including a la carte items and Jano Ahar outlets. So, menu, tariff is the job of railway board. Now, please take clause 17.5. But I just placed those clauses so that my second leg of argument will also be covered by these clauses. Otherwise, I have to.
It's 327, 10 years.
No, ठीक है, चलो. Well, tenure is 5 years. But I
Yes,
don't.
yes,
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 I
yes,
don't.
yes.
I need not trouble you a lot
No.
with those. Yes. Now, please take me, Lord. Page number 320. I'm sorry, 321. 13.1. Thirteen point 13.11.2.
Yes.
So first is Rajdhani so and so train, and such a
Minuent tariff, how is it relevant? You have to pay license fees.
yes.
Minuent tariff.
Now, based on this, my lord, presumably subject to correction by my learned friend Willard,
Yes.
this would apply. I'll tell you what why.
Yes.
First, fixation of menu tariff, and then fixation of license fee.
Right.
I need to demonstrate before your lordship that both were initially with the Indian Railways or the Railway Board, and subsequently a part of it, my lord, was conferred upon the IRCTC, but fixation of license fee was never conferred upon.
We are concerned with license fee.
Then, my
Let us
lord,
stick to the
yes.
license.
Then your lordships may kindly take, my lord.
17 may be relevant.
Yes, 17.5 at page 320.
Yes.
But 17, it starts from 328, renewal, etc.
17.5 is relevant.
17.5, the license fee shall be revised and reassessed at the time of each renewal, subject to minimum increase of 10% of so and so.
10%, yes.
Yes. Now, sales turnover is also contemplated in catering policy. This year, Lordship would find at 18.3, the next page. At the time of renewal of license fee should be enhanced, reassessed based on actual sales turnover of the unit. License fee will be reassessed and revised at the time of each renewal, subject to a minimum increase of 10%, minimum of 10% increase over the prevailing license fee of the unit to arrive at such and such. The rest, my lord, I don't trouble your lordship. Now, this was the one which was prevailing, my lord, at the time, my lord, when I get the licenses. Then, my lord, comes, my lord, the CC 78 of 2012, which my lord will find in the next volume, that is volume 4. Yes. Please take me to page 354. I believe Mr. Bhattacharya has placed this.
64.
354. Oh, I'm so sorry. It's in the third volume itself. I'm so sorry. Third volume, the last portion.
Three, 5, 4, yes.
Yes. But this is commercial circular number 78 of 2012.
12, yes.
Yes. But gradually, my lord, I'll come as chronologically, my lord, I'll place all this. Now, this is the Railway Board, my lord, writing to the general managers of all the railways. The tariff and menu of standard meals, breakfast, so-and-so was last revised on so-and-so on receipt of representation for various quarters. To review the tariff and the menu of the standard meals, breakfast, tea and coffee, board had also constituted a committee to study and suggest revision of tariff and menu of standard meals. So, this is a job of the board. Now, turning the page, please take me at paragraph 4 at the bottom. Railways may work out the amount by which the license fee may go up on account of changes in the tariff and adopt suitable means to adjust the license fee on this account and take necessary action. So, up to 2012, nothing is conferred on IRCTC. Then kindly take me to the next CC, which is of 2018 at page 357. At the next volume, volume number 4, the first page. This, my lord, I need to, my lord, read slowly because this may create some confusion. Again, we are Railway Board writing to the general managers of Indian Railways. Kindly see the subject. Subject is revision of tariff of tea and coffee only.
Yes.
The menu and tariff of the standard items notified with a CC 78 have been examined in board's office, and accordingly the following is advised. Tea, coffee in pots as prescribed in serial numbers, etc. of CC 78 shall be excluded, discontinued from the standard menu. Tariff of tea and coffee prescribed in so and so is revised and fixed at ₹10 each. However, standard tea at the rate of ₹5 is prescribed, vide, etc. shall continue to be provided. Since the tariff of the standard food items fixed and notified earlier in CC 78 are inclusive of applicable taxes as per prevailing central state government instructions from time to time, that is service tax on the outdoor covering GST introduction, since introduction, the revised tariff of tea, coffee, vide item 2 above is also inclusive of GST as per extant instructions in CC 79 and CC 21. Therefore, the licensee service providers will not collect any amount other than the fixed tariff.
Subclass 5 provides similar to 2012. Same.
Yes.
After the bold letters, same.
Yes, same. Therefore, Millard, what is the conferment on IRCTC is, Millard, subparagraph 5.
Yes.
Railway stroke IRCTC shall ensure implementation of the revised tariff within the framework of the terms and conditions of the contract in vogue. Railways IRCTC may work out the amount by which the license fee may go up on account of changes in the tariff and adopt suitable means to adjust the license fee on this account and take necessary action accordingly. But I apprehend that the source of power of IRCTC may be tried to be derived from this subparagraph 5. But that is why, Millard, I respectfully submit in advance that this subparagraph 5 or whatever has been conferred under subparagraph 5 is only confined to revision of tariff of tea and coffee. It cannot take into account, say, some revision in, say, breakfast items. But this is the only clause in which I found that some sort of revision has been permitted. Now, this is not a wholesome power conferred on IRCTC to, Millard, revise the license fee in respect of all other items. My respectful submission would be, I'll develop later on, to indicate that this does not confer powers to revise outside any item except tea and coffee. Then, Millard, the next one is page 300 and, I'm sorry, 364. Now comes, Millard, CC 60. But this is the commercial circular number 19 of 60 of 2019. Subject is revision in menu and tariff of catering services on Rajdhani, Shatabdi, Duronto and standard meals on Indian Railways. Then, Millard, they refer to the previous commercial circulars. Now, please take, Millard, at page 365. Item number, paragraph number 2. The revised menu of standard breakfast, etc., shall be as per enclosed annexure, etc., etc. Then 2.2, the revised tariff on standard meals is under, etc.
But this circular has no corresponding clause regarding license.
This is my
only tea, coffee, not the others.
Not there. So CC 60. Again, under that, there is no scope of any revision.
Mr. Shane is not interested in tea, coffee.
I require only 1 minute of your lordship's time. Your lordship was pleased enough to give me time yesterday. The matter has appeared.
Yes.
Item number 2.
Sir, 1 minute, yes. This will be, we'll continue with this tomorrow, Mr. On Monday. I'll just keep it parted.
But only one request, Millard, if it could be the number 1 matter, Millard. Because if I miss on Millard Monday,
4 people are vying for that place. Very well, this will be number 1.
because I am not available on Tuesday, therefore, Millard,
Oh,
so
that's very well.
or you can Lakshmi keep it on Wednesday.
No, if somebody prays on your behalf, if it is not taken up for some reason, let it be, probably it will be number 1. I don't know whether I have directed heard in part for further hearing on December 4th.
But I'm putting my learned friend on warning. If he goes to the IRCTC canteen,
Yes, I was
I
just
don't know what
wondering.
he will be served after.
Yes, I was just thinking of the IRCTC canteen. Exactly that.
Fortunately, it's a Friday. He won't have tea or coffee today, so.
2 Tadakun. 2.
But this is a matter relating to coal transportation. Your Lordship has dealt with these matters, coal transportation from Nagaland.
Yes, yes.
Last matter, it was at the checkpost of Assam-Bengal border, it was detained. Rather not detained, it was not allowed to pass through. They were not checking the documents only. Now, my lord, Alipurduar it has crossed, but at the checkpost of Kuch Bihar, the same problem. And now we have all the same documents. SOP from Nagaland to all the SPs. As per the SOP, my lord, the transit challan, the e-way bill, the tax invoice, everything is there. Now, after the truck reached, they asked us to come back to the Alipurduar border. It was waiting there. The documents were sent to them. No response. Now, today, after the matter was, the petition was served, at 2 o'clock, they were called again. Now the truck is at the border, at the checkpost, presently. And the documents, they are supposed to clear the documents. Now, my lord, only I'll show your lordship the documents which I have, as per the SOP. These are the same documents which I have shown. My lord, only thing, I am now.
These are perishable, Mr. Shen. What are the goods?
Coal. Now, my exit pass, the e-way bill, that is going to expire for the second time on Monday, 4th. But what I am saying is that, my lord, now they are checking the documents. My specific instruction, I have the GPRS printout also.
Your vehicle may be cleared by tomorrow.
Then Monday, your lordship will keep the matter, and the writ petition can be disposed of. But if they do not, they still detain it, keep it detained, then they must give your lordship the reason. And then then the matter has to be heard, that whether that such detention is wrongful or illegal. And what was the problem, my lord? Whatever was happening, the trucks were coming and a police complaint was being lodged. So, my lord, I had to keep the trucks so long on the other side of the bridge near the Alipurduar border. Because if I come...
Not so urgent that it cannot wait till the other matter which I was taking up before.
No, only
this
thing
is already the second item.
Yes. I'm only saying on Monday the e-way bill will expire again.
Achha.
That is the only thing, my lord. And it has already come from Nagaland, reached Kuch Bihar. So, my lord, the entire consignment, I will have to again go back, get an e-way bill. Now, my lord, it is on their process of they are now scrutinizing it, I am told.
I don't know what to do. I mean, we cannot preempt the issue. I mean, if
No,
they
your lordship,
scrutinize and release your vehicle, then we cannot.
Then your lordship will, I will just.
There's a scope of passing any order at this point of time.
Your lordship can only record that if they find the documents are in order, they will allow the truck to pass through. And your lordship will kindly record these documents are already on record. I'm showing your lordship, these are the documents. I cannot improve on that.
Mr. Shen, that is the law. They have to release your
kindly just give us that direction.
There's no occasion to do that. Mr. Shen, what will be the direction then? Then if the
case,
documents are in order, they'll release your vehicle. That in any event will happen.
That is not happening.
There won't be any.
But my case, in fact, even on Monday,
there has to be a prelude to every order. I mean,
even if
just like that,
that's the thing. On Monday, I would be urging before your lordship for every consignment. If I have to come to court.
That is the difficulty, yes.
That is what is happening. For every consignment I have to come, and I will show you instances where persons not having this transit challans and everything, they are coming within 24 hours.
Mr. Shen, this has to be heard out.
Lordship will kindly record my submission.
Mr. Banerjee, what is the difficulty? The documents are not in order.
Well, may I say this? This writ petition was with your lordship served yesterday at 5 o'clock.
Yes.
I got the brief sometime 11 o'clock in the morning.
I immediately asked the SP for instructions. The SP says this truck is nowhere near the border. This truck is nowhere in my check post. He sent person looking all over the check post. The truck had not approached at all, neither with documents, nothing. Thereafter, at 2:45 this evening, some time ago, the truck has come because he's made the affirmation that he was in the Assam Bengal border in the assembly. He at 2:45, the truck has rolled in to the check post. Thereafter, he has sent a word because we are monitoring every movement of his. This particular, they've given the truck number. So we have sent a word. As of now, no document has been presented at the check post. And this instruction, I'm saying, as I was walking into the courtroom, I spoke to the SP. Because as I was told this matter was being mentioned, I was in the library. Coming down the corridor, I called up the SP and asked him. He says, as of now, we have tracked it. The truck has now come. But as of now, no document has been presented before. How can I tell you anything till I see the document?
Kindly see all my documents. I have given an email to them.
Before the documents are produced and checked, we cannot pass in.
But I'll tell you, Lordship.
Let us come back on Monday.
But only one thing. Kindly come to one page, page 46. My learned friend has been given an instruction which, greatest of respect, I say, cannot be true.
Why do you say that?
Kindly see page 46.
Yes.
I have annexed the GPRS copy that the truck on this date was in the Alipurduar side border of the bridge.
Allowed.
And that is my specific pleading. Kindly come to paragraph.
Where is it now, you said?
Now it has gone to that check post. Kuch Bihar side. There is a bridge, my lord. After you cross the Alipurduar check post and you cross.
Anyway, Mr. Shen, let us come back on Monday because.
Well, Alipurduar has allowed it. I have come to the Kuch Bihar side. And the truck is waiting there, your lord.
It has to go to my Kuch Bihar check post.
It has. Kindly come to page 47.
Produce your documents, go through the Kuch Bihar check post also.
It is already there. Kindly record my statement.
Even page 50, sir.
Kindly come to
What
page.
What is the use of recording your statement, Mr. Shen? I don't understand
again,
this.
because
What sort of an order are you expecting now?
Because again,
before the papers are checked by them, how can it be?
No, I am not saying. I am saying that this instruction is not coming to my learned friend.
Whichever way the instructions come, Mr. Shen, I cannot pass any order at this point of time.
No, only kindly come to page 50 once, my lord. Kindly see page 50.
No.
Only one thing.
Let us come back on.
Kindly see, my lord, page 50.
Yes.
24th of November, this is a communication already given to the Superintendent of Police, Kuch Bihar, that this is the truck with the transit challan, which is already coming. Kindly see.
I don't understand. What sort of an order are you expecting
But
now?
I am only saying this while my learned friend is saying my truck has not gone there.
Now it has come.
2:45 it has.
2:45 it has, and the papers have not yet been produced at that point of time. Now might have been produced.
But this kindly your lordship will record that this is my submission. This cannot be correct. 29th May, kindly see, I have given the
Recording
mail.
that your vehicle is in Kuch Bihar without anything before, without anything after that.
No, it is.
This is not a. This is a court of law, Mr. Shen.
I am only
This
saying.
is not a check post. You are confusing the check post with the court. No.
Only one.
Extremely sorry. No.
Otherwise, this problem will continue.
Yes, it will continue. What can be done?
But this is I am not saying your lordship that it's a word versus word. I am showing your lordship.
The Shen, the same recording can be made on Monday when the matter is called on for hearing.
Monday difficulty. What will happen? I am not that. I am only saying my stand. Your lordship will kindly record because something different is coming to my learned friend from there, and I am showing on the basis of the documents.
Learned counsel for the learned senior counsel appearing for the petitioner insists that it be recorded that the vehicle in question is allegedly on the Kuch Bihar side of the border, of the inter-district border of West Bengal. Full stop. Learned senior counsel appearing for the state submits that the said vehicle came in only at 2:45 this afternoon and no papers had as yet been produced with regard to the in respect of the vehicle till the last instruction was received by him.
Just as the matter was being called.
But 30th November, I have
next
given
para.
them a mail recording where
Such contentions are controverted by learned senior counsel for the petitioner. Full stop. Be that as it may, due to paucity of time, the matter cannot be taken up today. Full stop. Keeping in view the urgency pleaded by the petitioner that the excise, what is that?
E-way bill.
the E-way bill, E-way bill of the vehicle is due to expire on December 4, 2023, comma, the matter be placed fairly at the top of the list on the said date. Fairly at the top means that it will be the second item after Mr. Datta.
That matter, my lord, but only one thing, my lord. Your lordship will kindly record that if they may scrutinize the documents and take appropriate decision.
If they don't present the documents, what do I do?
The documents are being